One matter for B group mallards. This matter pertains to caste certificate mallards. So now government, they are framing mallards, caste census mallards. If the caste census is prepared mallards, then it will be very big problem mallards. Is it our roster? Please mallards.
My lords, this is a miscellaneous first appeal, KPID matter, my lords. On the last date of occasion, this honorable court was had granted interim relief to deposit a sum of rupees 1 crore within 3 weeks. Since the appellants have not deposited any amount, my lords, I am moving this matter, my lords. In view of the urgency that we
But
have
you
to,
require to move it, there is no stay then.
my lords,
If the amount is not deposited and if it's a conditional order, what is the necessity to move it at all? There is no stay then.
no, my lords, we have to move the property for conducting auction, my lords. That's why we are moving them.
There is no. Correct. The auction can be conducted through process of court because now there is no stay because the amount has not been paid. It is a conditional order. You require to move it.
Yes.
You want to? Yes.
On submission, my lords, serial number 8. I'm for the respondent number 2.
Just a moment, please wait. Any other submissions for any other motions? Yes, please call the page wise. Page 1, number 1, page 2, number 2 to 6.
Serial number 3, my lord. Kindly granted 2 weeks time, my lord. Literally translated copy not ready, my lord.
Family court matter.
Yes, ma'am.
Serial number 8, my lords, I'm for the contesting respondent 3 to 8. I'm for the respondents 3 to 8, my lords. I have informed my friend. Next week, my lords.
You informed.
No, I mean, please.
I am here for the appellant. Court may fix a date then.
Please give a date.
Serial number 9.
Achha.
Yes.
In serial number 9, government advocate was required to secure the records. I do not know whether records have been secured.
Let's see. Let the item be reached. Please wait.
Minutes.
Yes.
Serial number 22 minutes.
Please wait. Yes.
But serial number 16, seek for a week's time, my lord.
I appear for the
Appeal filed by the
respondent,
state.
my
I've
lord.
informed the counsel for the
The
respondent.
small matter, my lord, wherein it's covered with the order, wherein the tax can be levied only on the consumption, not production. Kindly a date may be fixed, my lord.
Can be taken up next week, my lord. Any date convenient to your lord.
Let's
Please.
have it on a date.
Lord, serial number 15
Yes,
minutes.
please give it.
Serial number 15 minutes. 2 weeks time may be given, lords.
Yes. 15 can be.
Please, please.
Lord, serial number 19 minutes. Appear for petition. 2 weeks time may be given for.
Have you informed the other side?
Lords, it has been informed, my lords.
It's an admission matter.
Yes, my lords.
You want it adjourned
Yes, my lords.
at the request of the counsel for the petitioner. Just after
My
2
lords,
weeks.
serial number 20, my lords. I am for the appellant. The needful is done, my lords. Even the other side have filed the written submission.
Please be here. Yes.
Serial number 22
My lord, serial number 48, my lord.
Just a moment, please.
I am appear for the appellant, my lords. Seek for 2 weeks time, my lords.
22.
22.
I-
On the other
From the
side.
others.
My lords, I am for the respondent. Kindly limit it to 1 week, my lords. Because it
My
was a university who had to produce some documents before your lordship, which they have not yet ready. But a week's time may kindly be. Just a week's time, my lords, not 2 weeks.
Lords, now, it can be listed on November 5th, my lords.
Can it be
November 5th, my lords.
5th of them?
Grateful, my lords.
The last abstained. Serial number 43. Serial number.
My lord, serial number 48, my lord.
Just a moment, please.
Page 80, 31 to 33. Page 90, 34 to 38. Page 20, 39 to 41. Page 21. 42 to 43.
Milord, 43, may I request for next week, Milord, I am not well today.
Can it be 43?
Okay, 43.
43, who appears against you?
Milord, I will inform Ashok Naik.
You inform.
I will. Please, please.
Page 22.
42.
Just a moment, 42?
42, my lord.
Yes,
I'm for the appellant, madam.
yes, who
kindly-
appears against you?
Again,
My lords, I appear for respondent number 5. I have no
Yes.
objections.
2 weeks, my lord.
Can it come after 2 weeks?
Yes, my lords, I have no objections, please.
Yes, list after 2
Grateful.
weeks at the request of the learned counsel for the appellant. Yes,
My lord, serial number 48, my lord.
Page 27. 46 to 51.
Serial number 51, my lord. This matter has been settled. After 4 weeks, any date may be given. We'll report settlement.
it is submitted by the learned counsel appearing on either side that there is a chance of settlement in the matter. List after. 4 weeks. Yes. Yes, counsel, which is the item you wanted to mention?
My lord, serial number 48, I'm appearing for appellant side, my lord. Pray for a week's
Serial
time.
number?
48, my lord.
48. Yes,
Pray for a week's time, my lord.
have you informed the other side? It's an
I
MC
will- I
matter.
will inform, my lord. I will
Please
inform, my lord.
Please inform before making these submissions in the morning,
Yes, my lord.
because we don't know whether the other side has any urgency in the matter.
I will inform, my lord.
You are for the husband.
Hello,
You are for the husband.
my lord?
You appear for the husband.
Yes, my lord. Yes, my lord.
Is there any maintenance to be paid? Is there any maintenance remaining unpaid? Hmm. The learned counsel for the appellant requests a short adjournment, list after 1 week. Yes.
Admission, seal number 1, A. Ravi Shankar.
Matter was admitted. Kindly see the order sheet dated 30th of June 2022 and the last hearing date 30th of June 2022, third line. Heard on the question of admission. Appeal is admitted for hearing. Heard on IA 1/22. After hearing the learned counsel, it is directed that the operation effected the order passed with the learned single judges main state till the next. So IA 1/21 is also disposed.
What about the other, the connected appeal?
Connected appeals.
735, is that?
Same order. In fact, Same order. so far as-
But then it says on the last date, 17/9, Lease matters for admission on 21st October.
Yes, my lord.
Lord, last date it was
And one
posted
more,
for.
sir. One more, sir. On 17/9, my lords also dismissed my other interlocutory application on the ground that the email communication has gone to the respective respondents. So another application filed by me for order 5 Route 20 was not, did not sustain itself because it has spent itself.
Now the respondents are all served.
Well, so in my case, the respondents are, that is the first case, the respondents are all served.
Yes.
We have 2 persons have challenged the learned single judges order.
Hmm.
That is RRB.
Hmm.
They may have to take a similar step. Otherwise, if my lords were to hold that the service that
Lord,
is made
on
in this
previous
case.
to previous state, the learned court advised them that if the notice is served in the first case, then it will be considered that second case also it is served. So in the first case, that is 647 appeal number, it has already been served to all the respondents. So
Yes, therefore, it is,
If my lords were to hold that the notice is sufficient.
can we hold it sufficient? Does anybody have any objection?
It is the petitioner's money. The petitioners,
Yes.
some of the petitioners are only represented now. If my lords were to hold it is.
So, heard
But
the
on
learned.
previous date, it was posted for arguments. Admission has already been done, as sir said. So,
So it can be posted, passed over today for arguments?
yes, Lord, we can.
Can it be?
Lord,
I'll
today-
prepare a synopsis. Sir. Make it myself.
Lord, it's an appeal which is pending since last 3 years, so.
What is the subject matter?
The
Appointment in,
Lord,
in the bank.
appointment, my lord, and writ petition it ordered in our favor. Bank we're supposed to give job to all the respondents, but
It has been stayed.
it has been stayed, my lord.
So you want a,
It is with respect to a reserve.
short date.
My lord, today if we can argue, then,
I'll argue with synopsis, I'll argue next time.
Next week,
my lord, from before 25th, if it can be.
25th may not be possible. We are on 21st today.
21st.
Lord, 25th to 5th are not available, so after 5th.
Then we'll have it after 5th. The next date,
After 5th.
please be ready for
Sixth.
arguments. We'll list it,
For the
7th November. 2:30?
2:30.
Yes, my lord.
Yes, the learned counsel appearing on either side submit that the service of notice to the respondents in writ appeal 735 of 2021 can also be held sufficient. The notice is therefore held sufficient in the connected appeal as well. List at 2:30 on 7/11 for final hearing.
Interim order.
Interim order shall remain in force till then.
Okay.
Please be ready for final hearing. If there is any synopsis to be filed, please exchange and make it available to the court also.
Number 2, government advocate.
Correct, correct, correct. For the entire, it says that the entire additional list is released.
Lords, appearing for the respondent caveator. Apologies, in the last 2 days of hearing, I was held up in other courts, so I was unable to attend before your lordship. Lords.
Just for a short accommodation. It can be taken up on 4 levels. The other matter which he is appearing is also adjourned to 4 levels. Can be taken up on the same day.
Lords, in this,
Can it be 4/11?
my lords, 411 may be posted, but one submission is that, my lords, in the impugned order which the government has challenged, the learner single judge has already given the liberty to the respondent government in the writ petition to pass appropriate order, notification, circular, etc., based after cancellation, after quashing the impugned notification before the learned single judge, my lords. Subsequently, the government has, the appellant government has issued a notification in the year 2022, which is I have already made a record in the writ appeal, my lords, wherein the learned single judge order is reiterated, and it has been stated that in view of the order of learned single judge, we are hereby enhancing an honorarium of the town and municipality concerned panchayat library supervisor.
Therefore, the judgment of the learning single judge
It has
stands
been
complied with.
accepted, my lords.
Hmm.
That's the contention of the respondent. So if the
So that is an appeal maintainable after complying.
ASG will make it.
It appears that it has become infructuous. Yes,
Yes, so I don't have it.
yes. A learned government advocate submits that the additional advocate general is appearing in the matter. List on 4/11. The memo dated 17/1/2024 and 13/2/2024 shall be looked into and instructions made available on that date. He's produced the documents and filed a memo for dismissal. Please consider those and tell us whether
Please.
there is anything surviving.
Please.
3 adjourned. 4, Venkat Reddy CM.
Right, Malad. Petition for get a probate. That is dismissed on the one day loan, they are exam in the attesting witness.
Sorry?
Exam in the attesting witness.
This is the-
Within law.
we had that.
Therefore, I filed an application for additional evidence, Malad. Yes,
No attesting witness was examined.
not examined, madam. And the part of
But
negligence
the attesting witness is not available.
is available. Therefore, I filed an application now, Malad, before this
Sir.
court. Kindly remand back the trial court. I will permit to the examine the attesting witness. Both are alive. There is a negligence on part of the appellant only, my lord. The second apology, they did not examine the witness before the trial court. Therefore, I made an application before this honorable court, my lord.
Who were the attesting witnesses?
As a distant relatives, my lord. One Ramanjaneyulu, another is Munivenkata Gowda, my lord. Therefore, my humble submission, my lord, kindly remand back the trial to the trial court. Well, permit me to examine the attesting witness.
Yes,
Yes.
heard for orders.
Preliminary hearing, 5. T. Mohandas.
Item 5.
D. Mohandas.
Anybody appearing?
Cancellation of grant.
Yes. Cancellation of grant. Yes, no appearance list on some other day.
Six, M.N. Damodar.
15 days in filing the application to bring the LRs on record.
ನೀವಿಬ್ರು
2022.
ರಜೆ ತಗೊಂಡ್ರ ಅಂತ ನಂಗೆ ಅನ್ನಿಸ್ತು.
ಫುಲ್ ಟ್ರಾಫಿಕ್
ಟ್ರಾಫಿಕ್ ಆಯ್ತಾ?
Continuation of delay of 15 days in bringing the LRs of deceased R1 on record. IA 3 of 2022 is filed for setting aside the abatement. And IA 4 of 2022 is for bringing the LRs on record. Having considered the contentions, having considered the averments in the affidavit filed in support of the applications, the applications shall stand allowed. Notice has to be taken. Notice in the- No, notice in the- Notice has to be- Yes, notice in the appeal.
Please
The
state.
amendment of the cost title shall also be undertaken by the appellant within a week.
Notice on the main is already ordered.
Notice in the appeal is ordered.
Notice of the IA.
Before.
Before that notice had already been ordered, then that is not required. The amendment to the cost title shall be carried out appropriately. Okay. Thereafter, IA came.
So that notice of appeal has not served on the
No,
legal.
it was after the appeal was admitted and, notice was issued in the appeal, that R1 died. Thereafter the. IA is filed. Correct. Correct. So the appeal stands admitted. No? Yes. Issue notice in the appeal to the legal, to the original. In the appeal.
Two things. One is notice of application, one is notice of appeal.
Notice of appeal is probably served only on our, thereafter he dies. So the appeal notice now has to go to our, 1A2.
Notice was served but not appeared. He should be.
7, Sampath A. BDA.
My lord, the lordship has heard for a long time this matter for Arkavati layout. But I just kind of undertook that, my lord, I will not challenge the notification, only whether the, my lord, the report of the committee, my lord, what has to be done, my lord, they have to clarify. They say, my lord, that they will act as an appellate court and they will adjudicate and they will say reject or then, my lord, the purpose of forming the committee, my lord, not serve. That's the only.
Lord, in similar such circumstances, my lord, the reports of the honorable committee, my lord, were placed before the BDA, and BDA and the state government has taken certain decisions. Those decisions are also before the learned single judge. Learned single judge is examining that. But this is not a question where, my lord, a new thing has been brought into in the present appeal, whether the order of the learned single judge is justified or not. Whether the learned single judge constituted a committee to look into all the grievances as raised by the petitioner and other landowners. But that has attained finality, and the division benches of this honorable court has upheld those orders. But now a new thing has been tried to be introduced in the present appeal, saying that, my lord, the order of the committee should be final. My lord, it's a committee. It is for the authority, my lord, is as good as any other committee, my lord, which recommends. My lord, after that, my lord, it will have to, the BDA will have to take a decision. For a moment, my lord, even if the committee says, my lord, this land should not be deleted from the acquisition proceeding. Lord, if the BDA and the state government were to come to a conclusion that it is not feasible for the authority to form a layout in a particular portion of the property. Lord, for an example, Lord, 25 guntas of a land.
Hmm.
25 guntas of a land adjacent to 130-40 site is directed to be.
Just a moment, is it pending before the government for consideration now?
Please.
What is the status of the report as of now?
No. And what has been now said is he has not gone before the committee. He has to go before the committee. Committee has to take a decision. He's anticipating something against or in favor of him. No, what is now trying to say is I'll go before the committee. But what the committee takes a decision should be made final.
Are not challenging judgment of the but is seeking only clarification with regard to the action to be taken by the BDA and state government on the report submitted by the committee as directed by the. What does the learned single judge say?
The learned single judge has constituted a committee.
Yes.
And then Lord, the learned single judge says it is for the BDA and the state government to take an action thereafter, either to delete or to acquire. What has happened is.
Just a moment.
Yes.
If the committee is of the view that it is to be a self-contained layout, a report to the said effect shall be submitted to the BDA, upon which BDA shall delete the said lands from acquisition. However, it is made clear that if BDA has taken possession of such lands and has already formed sites, allotment made, then claim of members of cooperative society would only be considered, and it is made clear that said benefit would be available only to the applicants or members of the society, union, association who have purchased the property under the registered sale deed from such housing cooperative society or house building cooperative society or registered union or registered association. Two vernacular papers consequent. So we at liberty to examine as to whether BDA has undertaken any.
Yes. If I just, my lord, the little, my lord, the brief, like was it argued long back, let's just refresh.
What is now up before my learned friend starts? Not 25% of the work, which by virtue of this learned single judge's order, the committee has already taken a decision. But some of the decisions have been negated by the state government because it's a state which has to. For example, some of the difficulties what the BDA has come across is 25 guntas in a particular property has been left out from the acquisition proceedings by virtue, is recommended to be deleted from the acquisition proceedings by the committee. Adjacent to it is a 30-40 site. Committee says you acquire it. Not whether I will be able to use that 30-40 sites is left to my domain, is what I'm trying to say. Is only for 30-40, I cannot form a big road and connectivity, all those things, whether it's going to be viable for me or not viable for me is what I have to decide. The committee is making a recommendation only on the basis whether the 6 guidelines issued by the Honorable Supreme Court have been followed or not. Is only the examination is only to that extent. Not now, my learned friend is coming and saying the committee's order should be made final. If the committee says this land should be deleted, it should be deleted. And the BDA should not say that I want the land. But what if the adjacent land, which is not a subject matter of an adjudication before the committee, is already there in the acquisition? And Lord, I should not be deprived of taking that decision. Lord, that is all. Lord, otherwise, the order of the learned single judge has attained finality. The Honorable Division Bench has already upheld it. Lord, now introducing this, Lord, may not be. It will change the entire course of the adjudication before the committee also.
Let's see.
We'll hear you. Shall we
Please.
pass this over and hear you today?
Please, Mangesh.
You ready?
Please.
No. With regard to the upholding of the order of the learned single judge by the division bench, the material is on
Yes,
record.
on the
judgment
last
is here.
occasion, I have placed it before your lordships that already. Yes.
We'll see whether there is anything which we
Please.
can consider it. If it has already been upheld by a division bench,
Yes.
then what further can we do in the matter is the only
Yes,
question. We
but
will
what
not
happens
be able
is,
to do anything.
if committee's decision if subject to your lordship's discussion, if the committee's decision were to be made as a final, but then I may also have to place on record as to what will be the effect of that recommendation, Lord.
For the first question to be decided is whether we can, as a matter of fact,
Please,
interfere in this appeal at all.
please.
Once the very same judgment has been upheld by a co-equal bench, whether what remains
Yes,
for us to
Yes, yes,
consider would be the
Please.
initial question which he has to answer.
yes.
Unless that is answered in the affirmative, there is no question of anything further being considered at.
Please, please.
So,
Okay.
8, adjourn, 9, V. Gangadharappa.
Here for the appellant.
yes. One acre, 33 guntas and survey number is 71.
Yes. Totally 4 items were the properties which were endowed to the Mutt.
Hmm.
And one Mahanta Shastri,
Hmm.
who was rendering religious service,
Hmm.
personally cultivating all these lands
Hmm.
during the period when the act came into force.
Hmm.
After his death, 5 children filed the application for registration of occupancy, right?
Hmm.
Claiming different bits of land.
Hmm.
Ultimately, the deputy commissioner passed an order granting 2 lands and ordering to forfeit 2 lands to the government.
Hmm.
Then appeals were filed before the Karnataka Appellate Tribunal. 2 appeals were filed.
Hmm.
There are no other applicants to these lands.
Hmm.
Then a compromise was arrived between the brothers and they submitted the compromise petition before the Karnataka Appellate Tribunal stating that these lands may be ordered to be granted in favor of so and so, with different particular survey numbers and different extent of land. That was not accepted and the Karnataka Appellate Tribunal allowed the appeal in part, confining the forfeiture in respect of one land only. So the 3 lands were ordered to be registered in favor of all these applicants, who are the applicants before the Special Deputy Commissioner. Now the writ petition came to be dismissed on the ground that some strangers' name were appearing for 1 or 2 years.
I'm sorry?
The names of some strangers
Yes.
who are not at all either the applicants or in any manner related to the land in question. Their names appeared in column number 2.
213, name of Ganganna, Uttarevanna, Govindappa shown as cultivators
Yes.
from 69 to 71.
Yes.
And
In
for
fact-
73, 74, name of Govindappa and Putta Nanjappa shown as cultivators.
Now kindly notice the act came into force with effect from 1st July 1970.
1st July 1970.
1970.
Hmm.
And persons seeking for registration of occupancy right under the Norms Abolition Act, they have to make an application showing that 3 years earlier to the date of vesting. 3 years earlier to the date of vesting, they have been in possession and enjoyment of the property. And as on the date of vesting also, they must establish. None of them have made any application before the authorities. It is only the sons of
Question
Mahanta
would only be whether the sons of this Mahant would be
Mahanta
able to
Shastri.
would be able to show that they were in possession and in cultivation
yes,
as on the
yes.
date.
In some of
For
the
3 years, as on the.
yes, my
date of
submission
effect.
before the Honorable Court is this.
Hmm.
In some years, only the name of Mutt is shown. Mool is Mutt.
Hmm.
In some years, the names of Panchakshari Deva, that is the father of appellants before this Honorable Court in this appeal, that was appearing in the revenue records. Except for 1969 and 73, 74. 73, 74 is not relevant for our purpose because the date of vesting is 1st July 1970. There is no order passed by any revenue authorities ordering for entering the names of the Putrevanna or Gangana, whoever it may be, whose name was appearing. So therefore, we made an application before the appellate tribunal. Having regard to these aspects of the matter, the Honorable Court felt it is necessary to look into the records of the Deputy Commissioner and directed the government advocate to secure the records.
67 to 70, that either the Mutt or
Yes,
your father was
yes,
the
yes,
cultivating tenant has
yes,
to be
yes.
shown. Now, is
Therefore,
that
only to ascertain those aspects of the matter, the Honorable Court directed
Finding is
government
that
advocate.
finding is otherwise? Finding is that for
there is
that
no
period,
evidence to show.
the finding is that for that period, somebody else's name is also shown in some cases.
Yes,
And there is nothing to show that the Mutt or the Mahant were the
we're in
cultiv-
possession of
were
the,
in possession.
para 8 is the finding.
Question of fact.
No,
Question
of course, to decide the facts, records are necessary. And this is what the bench has
No
felt.
fact where an authority has decided one way. And
There is
unless
no
you can-
other, kindly notice, no other persons have made any application. Even those persons whose names were appearing for 1 year or
That may not be
2073,
material.
74.
that may not be material. Because what is to be done is that you have to show your possession.
Yes, therefore only I request the court to kindly secure the records. Therefore, I will be in a position to show what was the position with regard to the entries in the revenue records.
But this stage of the proceedings, there is first one authority, then the deputy commissioner, then the appellate authority, then Learned Single Judge. We are in the 5th stage of the proceedings.
Please.
This court sitting in appeal from a
Order
judgment
passed
of
by
the
the
Learned Single Judge. Can we look into these records to find out whether the facts, it is not a question whether you were put on notice or something of anything which relate to procedure, we may have the power to do. But
Now,
for
if-
recording a finding on the facts,
If we are able to show before the court that in fact,
You
as
have-
on the date of vesting,
you can show it before the court. You can probably go there, get the RTI records. And if you can produce anything, maybe, again, this is a pure finding of fact.
then kindly
Unless-
adjourn it by 1 week. I will get ready because of expecting that the records which I wanted to look into, I thought that the
Yes, not at this stage, not in the fifth stage of the litigation.
anyway, I will
Re-examination.
I
of
will make
facts.
the submission on the merits of the case. Kindly call it next week.
Yes, the learned counsel for the appellant.
In
seeks
fact,
a
I mean,
protect-
regard to these facts only, the bench felt that it is necessary to get the records and look into the records. That is how the matter came to be adjourned. Otherwise, there was no need.
Not be proper is our view. Re-examination on the factual aspect.
That is what I am submitting, re-examination of the factual aspects. If it has not been properly considered and what is prevailing as on the date of vesting, if we look into the revenue records, that will also
For you
make
to
the,
establish that at least in the appellate stage before us for a consideration on those aspects, as we can.
yeah, I will submit the argument and then
Seeks a short accommodation list after. Give a date, please.
6th November,
it's,
10, Manjunath P.
What is this? Item 10, any appearance? What is this? Service is complete? Yes. Ma'am. Yes. List after. No appearance for the appellant, list after 2 weeks. It's 11.
11, Prashant Hedges.
My lord, I am appearing for respondent number 5 in this matter, my lord. May I request for a short pass over, my lord? My senior is on his legs, my lord.
Today may be a little difficult, my lords, to,
Pass over or on any
Yeah.
date?
so either Thursday or on the next Monday, my lords. Interim order has already been granted, my lords, after hearing. So matter requires to be heard.
28, you have 2:30. After, week after. 8, 11,
Very well, my lords.
Please,
8, 11.
publish.
12, M. Rajshekar.
For the appellants in this matter, lords, on the last date of hearing, lords, directed the government to secure the records, lords.
Hmm.
There were 2 sets of records.
Hmm.
Lords, the subject matter is only 15 guntas each, lords. That 3 applicants were there, 15 guntas were granted, and lords R4 got all the 3 lords extents granted to her name by lords false representation. That is the case, lords. So my case is that she is not entitled for 1 acre 5 guntas. She is entitled for only 15 guntas.
R4 is represented?
Please, lords, R4 is represented. It was very much here, lords.
Are the documents here? Can we pass this over? R4? Pass over.
Please, lords, please.
My lordship's kind permission. Previous matter, instead of 8/11, may I request it on 9/11? I've informed the senior counsel. Please,
9th, Rajayan,
Right.
2nd Saturday.
11, Monday,
11.
please.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
Instructing counsel is there.
12, pass over. 13, government advocate.
Kindly pass over, madam.
Item 12 or 13?
13,
13 minutes.
writ appeal filed by the state, my lord.
You want it passed over?
My lord, if it can be taken up,
Fourth time, madam, kindly pass over.
my lord, the reason is the matter had, the writ appeal has been, single judge has allowed the writ petition based on the order passed in the regular appeal, my lord. And that order is under challenge in a RSA.
Madam, RSA,
That-
that fifth time, madam, same
But-
ground, they can attain, madam. Kindly pass over. It's not
My lord, I have received the file for the first time, my lord. It can be taken up next week, my lord. I'll get instructions in this matter.
They are not in a position to even rectify the office objections, madam.
My lord, I have received the file for the first time. I'll make sure that things are taken
have
care
this
of
on
within a
Friday?
week's time, my lord.
Friday,
And we'll have it next week.
Monday,
Finally, madam.
Monday or Tuesday.
Grateful.
Yes, learned government advocate, seeks a short adjournment
29.
to get instructions as to whether the defects in the RSA have been cured.
Finally, madam, sixth time I taking the adjournment. Please, madam.
No further adjournment.
Yeah.
I undertake. I will not
Yeah.
take any further adjournment.
And undertakes that no further adjournment will be requested for list order.
14. B Vajan 2910.
Are we ready?
Yes, madam.
Can we pass this over and take this up immediately after the list?
Please,
We're only at 11:18.
please.
Pass over.
Please.
Hearing on again, symbol 17. Krishnamurthy.
Ready? What is the appeal about? Sorry? Yes, what is the appeal about? CST. Are you ready in the matter? R3 held sufficient, R3 is represented. Government advocate for R1 and R2. Can we have this matters to be heard? Impleading R7 to R17. Who are R7 to R17 in writ appeal 1296 of 2018? There is a 2024 notice has to go. IA 1 of 24 in writ appeal number 1296 of 18 is an application for impleading. Please tell us where the notice has gone.
Yeah, Ramesh.
I'm appearing for the impleading applicants.
You have filed the impleading petition.
Please,
IA 1 of 24.
please. I have one of
Impleading.
23. I have one of 23, I have filed an application.
Before.
1 of 23 is for impleading applicants. That is,
That is Milord Shobha, Bhagya and Katama.
IA 1.
Well, they have filed one more application. The copy was not.
Who are those persons? Those are the subsequent purchasers of the property.
They have the impleading applicants are the original grantee, LRs of the original grantee.
LRs of the original grant.
That is, please.
4 to 6. So both.
The grant was made in the
What about 7 to 17? Who are the applicants?
Milord, they have Milord dragon the matter. Milord earlier, Milord the assistant commissioner was passed an order, set aside the
Correct.
grant made in favor and the sale deed made in favor.
Sale, correct. So
The copy.
they've apparently sold it again.
Please, Milord.
And those, the subsequent purchasers are the,
My grandfather sold the property in favor of the PC Thambi.
understand.
But the assistant commissioner was set aside.
You
Then,
are,
Milord, they have challenged deputy commissioner. But deputy commissioner was confirmed. But writ petition was
you
filed.
understand, council, who are 7 to 17? Who are sought to be impleaded by
But they
the,
have not.
who are 7 to 17? Do you have a copy of the IA or the affidavit? 23, 4 of 23.
But the impleading application filed with.
Who are they?
They're relevant.
Whether they need to be, whether we need to put them on notice or not is a question.
Even though Milord, they have not local study, because Milord, they are not legal heirs of the Badgiya.
No, do you have any objection to this 1 of 23 being allowed?
Milord, any date may be given in this matter, Milord, is
Milord,
already the.
Milord, I'm sorry for, in this matter, my lord, at my instance, the impugned orders are passed.
We understand. We understand. The question is, there are several impleading petitions. We don't even know who they are. The applicant's counsel is not in a position to tell us who the persons he seeks to implead are.
Please.
We'll have it next week.
Please.
In the meanwhile, please get ready in the matter.
And also, my lord, the
A
director
date may
disseminate-
kindly be, a date may kindly be. Next week.
And also tell us whether you're objecting to their application.
Please.
That,
sir, the
that
cop-
appears to be, that has to be allowed. And your application, please tell us who they are and what is their relevance. The issues with regard to the sale by you, which has been set aside. So, suppose you have made further sales, that will make no difference.
Lord, here what happened, my lord, taking undue advantage of the similarity of the names, they have filed these applications. In fact, for them also land is granted, for me also land is granted. They have sold their portion of the land.
the date.
Much.
Yes, please give a date.
Madam,
Please be ready on that.
29/10.
problem.
Much.
18, government advocate.
Here for the caveat to respondent, my lord. There's an impleading application filed. I have not received the copy of the application, my lord. One nimsham, sir. My lord, this is an order passed by the single writ petition allowed by the learned single judge, where a grant made in my favor was cancelled. My predecessor in title was cancelled after 12 years. I really don't understand what's the purpose of the impleading application. If my copy be served on me, I'll file a necessary objections to it, my lord.
Please serve a copy so that if they have objections, it cannot.
I have serious objections to the impleading application.
Yes, the copy of the impleading application will be served on the learned counsel for the
Respondent.
respondent. List after. You will do it immediately, just after a week. Please file the objections in the list.
Yes, certainly.
Give 2 weeks.
Deeply appreciate.
611, 19 adjourned. Orders number 20.
That's for the appellant, my lord.
Sorry,
We have
number
filed
7.
a written synopsis and it is on the file.
Appearing for respondent.
For 7 minutes.
My lords, I see
They are
a
asking
short
to file
account.
as synopsis. It is ready, my lord, permit us, we will place it on record.
Matter can be heard,
On the.
non-filing of written statements.
So it is
synopsis,
ready,
everything else.
it is
Yes,
ready,
yes.
which is we will
Yes.
present, leave of your lordships.
It is submitted by the learned counsel for the appellant that the synopsis and the written statements are already on record. The learned senior counsel appearing for the
Respondent number 7.
correspondent number 7 submits that the synopsis will be placed on record during the course of the day. List on
811.
8/11.
Thursday, madam, Monday. Next Monday, madam. 28.
Next Monday, we don't have, may not be possible.
Tuesday.
11.
7/11.
Please, my lords.
It would be very long, my lord. 37 years to delay in filing the writ petition. 79 order. Learned single judge about a detailed order have been filed, writ petition came to be dismissed. That's the problem.
Hear it.
That's hearing.
7/11.
Please, my lords. Wait.
Could it be on earlier that,
Yeah, dates, we have several cases listed on
I
the,
can take a chance on that.
any day.
511.
Great.
21. Tribunal.
Yes, what is this?
My lord, this matters had come up last month. But to be taken up for final hearing, my lord, it's understanding that will be heard finally.
Can it be heard today?
Please, my lord, may be heard.
No, I must put up before also that it might take about 2 or 3 days. Therefore, if Lordship wants to adjust the timing, give a date for us to put it in the hearing itself. I am ready. Yesterday I prepared myself. But I have to tell the court that I may likely to take some time in this case. Yes.
If the synopsis can be provided, can the time taken not be shortened? We can look up. the
There are
matter and
7 volumes of paper book. All those volume records have come before your lordships. So I may have to refer to some volumes, not entire book and bore your lordship with all the unnecessary facts. Briefly stated, my case is this. Lord. In 1989, this factory was started.
Hmm.
At that time, there was what is called as team serving societies. They were contractors and they left by themselves, leaving only one employee called Govind Kellogg. Govind Kellogg alone remained. Then, my lord, all these employees who are presently contesting the case joined a contractor called Terrier Security Services. They were working there. When their contract was about to come to an end, they went to the civil court in Anekal and tried to get an injunction saying they should not terminate their services. There I was also made a party. There the complaint was their contract labor employed by this contractor. They are trying to terminate that service and the new contractor is likely to take over. Therefore, please give a granted injunction. That suit, I guess, as me, was dismissed, saying that I have nothing to say that between the two contractors. Principal employer, Bosch has nothing to do with it. Then, my lord, they raised a dispute after losing the suit, saying that the contract is sham. The question is, my lord, here is all these contractors had licenses. And they had registration, I had registration, and they had been paying, complying with all statutory, like Provident Fund, ESI, all these things were being paid by the contractors. Contractors deputed their supervisors to supervise their work. Allotment of work was made done. The labor court made a fundamental mistake, according to me. The labor court said, the union that is raised the dispute has no locus standi at all. I raised the issue, saying that I have my own union, contract by Maiko Karmikar Sangha. They are there as a union to represent the workers. If they want, they can raise the dispute. Now, you may remember there was a controversy. Air India, just as Supreme Court, Justice Ramsamy said, automatic absorption and abolition, all these things. This controversy was going on. So these workers also took the chance. They said, all right, let us go by Air India. Unfortunately, Air India was not followed by Supreme Court. Constitutional bench did not approve it. So these labor court, what it did, made a mistake was that in 89, these employees have joined service. At the time, you did not have a license, contractor. Therefore, they are your employees, which is contrary to the full bench judgment of this court and also the Supreme Court judgment in sale, Constitutional bench. So even if I did not have a license, they can't become my employees, principal employees, employees. Even on abolition, they cannot directly become. So the labor court had to consider, they said 89, I did not have license. But unfortunate thing in this case is, all these employees who are concerned in this case joined after 1991 and 92, 93, 94, 95, 96. No one was employed in 1989. So that premise itself was wrong with the labor court. The other mistake made by the labor court is, it said that L.P. Rao, one of the security officers in the company, used to sign the attendance register. That is, my lord, for the purpose of finding out how many they have deployed, contractor, how many people are working. Because under the Factories Act, your lordship knows, even contract labor will be a labor. Suppose some accident happens and a person's name is not found in the register, I have to certify. Therefore, L.P. Rao, your officer has signed that register. Therefore, they are your employees. These kind of.
Therefore, the question is only whether they are your direct employees or not.
Yes. That's all.
As simple as that.
When the subsequent contractor took over these employees, they gave applications to join them. That is, Unique detective, the present contractor. They joined the services also. And why their consent was required, they themselves gave applications, which are exhibits before the labor court, to join the new contractor. And in the labor court, the dispute was pending. These employees said, I will join the new contractor without prejudice to my right that I am not the employee of a contractor. That's all right. So that's what is pending in the court. But by the undertaking given by the employees to the court, I will join without prejudice. So they were employed. Even now they are employed.
Initially, were they employees of the contractor or were they directly your employees?
Initially, no time they were employees of the company.
That is the only question that
That's the only
requires to be considered.
Please.
Whether they joined with the subsequent contractor or not, without prejudice to their contentions before the labor court, may not be relevant at all. For the question to be decided is, initially, what was their status?
Correct.
Were they your employees?
They were not. Is my contention. The labor court says since the contractor did not have a license, they are your employees. Contrary.
Labor court, after consideration of all the material, comes to the conclusion that they were your direct employees.
Yes.
Therefore, the scope of interference in the by the learned single judge would be to the limited extent as would be available.
Unfortunately, the labor court, when she says the union has no locus standi, Gujarat Electricity Board by Justice Sawant's judgment will apply. Community of interest, my direct employees having to support it. All these questions will arise. Therefore, by submission to your lordship is the judgment order of the labor court and the order of the single judge. The labor court says unique detective agency did not have a license, which is wrong. M52 exhibit is the license. A wrong finding. That is approved.
When was that?
Why is the labor court?
No. When was M52?
94, 95.
M52 is in fact
Yeah,
2005. Unique detective, that contractor that is named. They come in 2005. Unique detective. Please, Malad. Unique detective comes in 2005.
Career services.
Therefore, before that, how was the?
They all had license. One aspect of the matter is, I applied for a license when the contractor changed. At that time, there was a great movement by the Labor Department. Because of Gujarat Electricity Board case, you should regularize all contract labor. Then what happened? This license was applied, was not replied. For 2 years, they did not act. The law says, Rule 29 of the Contract Labor Act says, if I apply for a license you don't consider in 2 months, it is deemed to be granted. So what is the legal consequence? I have a license. The labor court says, no, you should apply for a temporary license under 32.
Did any contractor who you say engaged them have a license when they were engaged?
Yes.
That would be the question which.
Only subsequently when they tried to renew the license, all this case again, by minute personal experience, I can
No,
tell
we
you.
just wanted to know what is the scope of the appeal.
The question is whether
So these aspects have been considered by the learned single judge also?
Yes.
But unfortunately not properly. And you appreciate, your lordship knows, even inference to be drawn from questions of facts is a question of law. I'm not Maybe for submission. The question is, once the labor court holds that this union has no locus standi, then what does it follow? Can they maintain the dispute? It's a question of jurisdiction. What the labor court says is, among the contract labor, they themselves raise a dispute, therefore there is community of interest. Community of interest, as your lordships are laid down, is that must be my principal employees must answer their dispute. There is community of interest because they are a contract labor working along with. That's what your lordships are laid down right from the earlier case of standard vacuum and all that. And the Hindu, the working journalists of Hindu case, Supreme Court said, community of interest, your employees must raise a dispute. You cannot go and join some other union and say that union can raise a dispute. There is no community of interest. That is first principal point. First point is itself wrong. Because Justice Savant in his judgment in Gujarat Justice Board, which I will point out to your lordships, says that community of this question of the employees raising a dispute, contract labor can be got over if principal employees support the issue. And their lordships hold contract labor by themselves, as the definition stands today, cannot raise a dispute. Justice, the FCA case.
There again, the question would be whether they are contract labor or not.
Correct. There's nobody's dispute. The suit itself filed on that basis.
And in fact, my lord, in Gujarat Electricity, it is clearly held that when there is a question of sham contract, then the contract labor who make the dispute.
Well, if I
can raise
comply with all statutory.
Just a moment, Senior Counsel. Let us interrupt for the purpose of, can you file a synopsis? Both of you can file a synopsis.
Please.
We can list it on a day, and an attempt can be made to.
In fact, I have prepared the synopsis and filed it long back.
In fact, my lord, it had been heard 2 years ago.
This was heard by 2 division benches.
The synopsis is on the file, my lord.
That will do, that will. Then we'll have it, when do we list it? At your convenience.
Then I'm commencing 28th.
Please, my lord, on Monday it may be less.
28th may not be possible. We've already listed several matters on 28th.
My lord, my only submission is there's a reference of the year 1998.
Correct. But you're still in employment.
In fact, my lord, my difficulty is for the last 3 years, I have not been paid wages. There was an application, my lord, that's a separate
That I
issue.
will answer you.
There's an application, my lord, on the last
Not
occasion,
now.
this had been heard.
We'll list it on a day. And
Please, my lord, it
hear
may be
you
taken
now.
up finally.
No. That is, my lord.
Because there are orders of this court
go and
directing them to
transfer
pay wages.
to
They had not
Neramantra.
paid those wages to me.
Half of my factory is sold. I don't require so many security guards. So I transferred. I didn't transfer, the contractor transferred. They said, you are not my employer.
Subsequently, this court has passed directions, my lord. If it may be taken up on 30th, my lord, if not on 28th.
7th or 8th.
My lord, any,
7th or 8th of November.
Huh?
7th or 8th of November?
7th,
Can it be? 7/11?
could it be taken up at 2:30, my lord? Then it may be heard.
I have filed already my synopsis.
Yes.
I'll also file my synopsis by tomorrow.
These
We'll
are
file
the
it.
broad points I would like to address your lordship.
Correct. 7/11, 2:30.
Most great.
I'm sorry, I could have gone on the case, but it got listed in the orders. I can't even mention. Much obliged, Lord.
Wait.
22 Adjournment, 23 Sachin BS.
22? 22 was adjourned in the morning.
Appear in 22 for the respondent number 17, but
There was somebody appearing for the respondent as well. Appellant as well as the respondent sought an adjournment in the morning.
Abhishek Malik Patil ಅವರಿದ್ರು.
In connected matter might be they have sought for adjournment.
There is a connected matter, Counsel.
ಅಲ್ಲ, ಅಭಿಷೇಕ್
You're talking
ಮಲಿಕ್
about item
ಪಾಟೀಲ್
22.
22.
22.
Your item is something else. Please
Yes.
check your
Yes,
item.
sir.
Yeah.
Yes, Sachin.
Already adjourned in the morning.
5/11.
My lord, since it number 23, my lord,
23 Sachin BS.
all the materials are ready, my lord, translated copy and all ready, my lord. May posted next week, any date, my lord, by then I will comply with the. office
Since
objection.
2021, my lord,
My lord,
they
because
could
my
not
lord, I
able
was
to
not
attend the
on
office
record.
objection. Even otherwise, I have filed the memo along with the
My lords, I will rectify all the office objections. my
Kindly
lords.
see I have filed a memo along with
Filing,
the,
recalling application, delay of
Yes,
days
my
to be
lord.
mentioned.
Yes, my lords, I will add.
Yes, comply with the office objections, we list it on a date.
Any date, my lord speaks.
Yes, learned counsel seeks time to comply with the office objections. List after 2 weeks,
Yes, my lords, any date, ma'am.
11/11.
Much only.
24. Rajesh Pettigar.
I filed one application, my lord. I have 1/2024, my lord, seeking permission to harvest the crops, my lord. I have cultivated the land, my lord, that scheduled property is in the position of the appellant, my lord. But the second respondent has not allowing to the harvest the crops, my lord.
Who appears for R2?
Last
Whose
date of
appearance? There is appearance for R2.
last date of hearing also they have not appeared. That's why I adjourned to today, my lord.
What do you say? Government advocate, do you have any instructions on this matter? What is this about? Is there a dispute with regard to possession?
Not position, man. In respect of form number 7, my lord, that is allowed by the land tribunal, my lord. Against that order, my lord,
Dispute is about
the
possession.
petition has been filed, my lord. Now interim order is operating, my lord.
Yes, what is interim order?
Staying the order of the learned single judge, my lord.
Petitioner is Venkatramaya.
And I am seeking permission to harvest the crops, my lord.
You were the,
Please, my lord.
you were the, before the
I
last.
am in possession, my lord. I am cultivating the land, my lord.
You were which respondent before the learned single judge?
Single judge, my lord. Respond number 2 to 6, my lord.
Official respondents have entered appearance, private respondents through their private counsel. (1964 to 74).
Earlier round of
Only the name
litigation,
of
my
the
lord.
petitioner which figures in the revenue records. What is the
Hello.
material to show that you are in possession?
Along with another application I filed, my lord, for temporary injunction, my lord. On that petition, my lord, the interim order has been granted, temporary injunction has been granted against the second respondent, my lord. In
What is the material counsel to show that you were in possession as on the relevant date? Have you produced anything?
Annexure P, my lord. Along with the application for temporary injunction, my lord. Annexure P, order passed by this honorable court, I have produced.
Possession is not at all admitted. It is the other way around.
Earlier on, I am in possession. I am in possession, my lord.
It is not found, counsel. Where, on what material do you say that you are
Okay.
in possession?
Kindly see the annexure P, my lord.
Annexure?
P, along with the application for temporary injunction. Along with I have filed, my lord. In page number 8, my lord, that the petitioner and all its supporters, we are and hereby restrained from interfering with the third respondent's cultivation and peaceful possession of the scheduled land pending disposal of the above petition. That petitioner, second respondent is the petitioner, my lord. PP number 1499 bar 1991 petition.
This properly served is also another question. What happened to the suit?
It was remanded back to the land tribunal, my lord. This is the third round of litigation, my lord.
This is in 3rd of August 1995. 26 quintas of dry land in 142/5 from our village, Madurai. What was the finding of the tribunal?
After remand, my lord, after spot inspection, is came to know that, my lord, the petitioners are and the appellants are in possession, my lord.
In fact, on earlier proceedings as brought out in order dated 3/10/2002 of the Land Tribunal, Venkatramaya has considered and accepted the fact that Yellappa, son of Muttaya, was continued to be in possession of the land in question under its cultivation during 71-72 to 73-74. And Tribunal in its orders confirmed the occupancy right in respect of the said land. Spot inspection with regard to status. Members of the Land Tribunal, along with the Tahsildar and Secretary of the Land Tribunal, have inspected the spot in the presence of Srinivas, son of Yellappa, and Venkatramaya, son of Narasaya, as well as in the presence of Srinivas, son of Yellappa. The villagers have specifically stated that land in question was in possession and cultivation of late Yellappa. It is now in possession and cultivation of his legal heirs. The petitioners have planted arakana trees and have also spread fertilizer. The attack is that the entries in the Pahanis were made in the name of Yellappa illegally. Therefore, he cannot claim the tenancy right in respect of the land in question. Decision reported and so on. So. At present, also in possession and enjoyment. When was this inspection carried out?
2017, my lord. On 26/5/2016, my lord.
No, he was in possession. Nobody was accused of it. The compulsion because 1974, whether he was in possession is the only question. No, he is in possession. Because the inspection conducted by the land. So therefore, I think the father story is. Absolutely no difficulty. Even this case, the fees in possession is equity. If the inspection shows that fees in possession, they should be. Here, we have to consider for deciding this issue is the possession in 1974. This is that the person does not come to possession. From today, it's still existing. No, but the other side is not entry. The other side is not entered appearance at all.
No, ma'am.
Is
They have
appeared.
filed wakalat.
There is a wakalat.
Already filed wakalat.
Let us. Please show it correctly in the cost list. We'll have it on some other day, a near date. Tomorrow can it be shown? This is the only question.
This is one question.
Your IA has to be decided.
Decided.
Let the name be correctly shown, because even if it is a small mistake, probably in the cost list, in the computer generated cost list
Please,
will
ma'am.
not come
Please.
tomorrow. Only for hearing the IA.
I am.
25. Brigade Charity.
Appear, appellant.
Yeah.
Give us a full-
Probably the question was in possession. For all the reasons they are in. It's- Correct. That is a good. Let us.
Not appear for the applicant, or they were supposed to state certain things before your lordships, the date of death of the respondent.
Order sheet. Date of death of respondent number 5.
My lords, an affidavit has been filed on 21/8/2024, my lords, by the respondent number 2. His limited knowledge, he has put it in the form of an affidavit, my lords, that she was dead. My lords,
Who is respondent number 5?
my lords,
How are respondent number 2 and 5 related?
grandmother of respondent number 2.
And you don't know when she died?
My lords, in the form of an affidavit, he has filed, my lords, his limited knowledge that she is dead, and all other LRs are already on record.
When was that affidavit filed?
21/8/2024, my lords.
Is that available?
Twenty-one, 8/24.
19/8/24,
Yes, I have.
affidavit dated 19/8/24
That's
What I have is.
by R2. 19/8, there is an affidavit.
Twenty-one. Affidavit of husband.
That's paper publication to, in respect of Respondent number 5 has already been taken out by the appellant.
Is also part, that is my grandmother, she's also. Gemma passed away in the year 2002 due to ill health. Gemma has no other in-laws and all her in-laws are already on. What do you say?
I
You know,
have no difficulty. If they say they are the LRs, it is between the court and the LR who's coming on record. I should have no objection not for that. The para 7 may be a little tricky.
Oh my God. She passed away in 2002 and there was a petition filed in 2014 with her name on record.
That
How did
is,
this come about?
There's an oversight done by the advocate on record back then, my lords.
that is why I filed an application for appointment of
There must have been a signature in the wakalat.
My lords, there are 2 Jayamas.
Hmm.
There's other Jayama as respondent number 11.
Who is that Gemma?
My lords, she is also one of the owner of the property, my lords.
A daughter
My lords,
of the original Gemma.
my lords, the family tree has been filed on the last occasion, my lords. The family tree has been sworn by late by Dasama, my lords. The objection was filed on 17/9/2024.
You have a contention of adoption by Gemma also.
My lords, there's an impleading applicant, my lords. We are not concerned with that. My lords, in the family tree of late Dasappa,
This family tree for whatever it is worth. We are very sorry, we can't even make out what is written here. The copy which has been served on.
my lords, it is not my affidavit, my lords. I'll have it typed and I'll have it filed, my lords.
We can't even make out the names.
Correct, my lords. I'll have it typed. The affidavit of family tree is sworn by Dasamma, not by respondent number 2. I'll have it typed and I'll have it filed.
This entire situation is a little worrying because of the subsequent filing of the writ petition with Gemma on record.
Correct, my lords.
Otherwise, it would have posed no difficulty. We could have allowed your application. If everybody else is on record, then the impleadment itself may not be necessary then.
Correct, my lords.
Because the rights have devolved on the surviving members of the family, then
We have
can
no
be
objection.
abated as against, can be held to be abated as against Gemma also, nothing, no other, therefore these applications may not be required. For allowing the application, the difficulties are this.
My lords, if
The grandson says he does not know when she died. 2014, there is
Allow-
another writ petition where she is a party.
no, there's
All
a
this
present
creates
writ,
difficulties.
present writ petition, not another writ petition, present writ petition before the learned single judge.
Oh,
That's
not
not
another.
another.
In this writ petition, without the death being noticed, she has been made a party.
Please.
Who signed
She is-
the wakalat?
She is a petition.
Who signed the wakalat would be the question. There was another Jayama who was a petitioner in the writ petition itself.
Please,
Two Jayamas. ma'am.
Is it the same signature in the wakalat?
Their identification is different. The wife of somebody. Lodge may kindly take page 5 of my appeal, where Jayamma, wife of Muniyamma, is one party, and the Jayamma, wife of late Srinivas, is another party. So they are not, even we had taken a paper publication. At that point of a time, they informed us that she is dead without disclosing the date.
Because we are aware of the year, not the exact date. That is what has been filed.
Usually I wouldn't have had.
Jayamma, wife of Muniyappa, the age is also not shown.
Yes.
Jayamma, wife of late Srinivas, is aged 55 years at the time of filing of the writ petition.
50 years is shown in the impugned order.
Jayamma Muniyappa, 50 years. Ramya Apartments, Jeevan Bhima Nagar. O.S. Raju stays in the very same house.
Lords,
He's not aware when she died. His own grandmother. A little funny.
But ultimately, I'll leave it to the court if whatever happens, if the appeal is allowed, BDA appeal, they all suffer together. The appeal is
If
dismissed,
the
my lord, it goes to the
Abatement
benefit
also
of
may
it.
not, abatement also may not make any difference.
Let's-
Abatement of the appeal as against
Jayamma,
Jayamma may not make any difference because you say the LRs are on record.
please,
Yes,
Just leave it at that.
Yes,
ma'am.
Because allowing this petition is difficult.
please.
With these pleadings, how do we allow the petition? Therefore, let things be as they are,
Please.
and we'll hear it on the merits of the matter.
Please, ma'am.
Yes,
Lodge may
heard
have-
both sides in the special facts and circumstances of the case. And in view of the submission that the fifth respondent expired in 2002, and that all her legal aids are on record, we are of the opinion that the applications do not require to be considered. Application for impleadment does not require to be considered. List. What about the other office objections?
Application, I have not filed an application for impleadment, no, I had filed an application for appointment of an administrator
With regard to?
with regard to the estate.
Estate of
Jayamma.
Jayamma.
No, I had no other
No.
option but no,
The other
Yes.
applications do not require to be considered
There's
because the
one-
LRs, they say that the LRs are on record.
Yes, but there's one more person who claims that he has succeeded to their interest by virtue of a will.
Or
That is there. Another.
Was filed
lords,
an impleading
filed an
application.
An impleading application has been filed by someone, my lords. If he has any claim, it has to be adjudicated before the civil court.
I leave it. But at the end, Lord, I should not be facing a situation where at some point of a time, somebody comes and says, my Jayamma was not her, it was abated against Jayamma. That's a risk that I am running.
all the other applications shall be considered along with the
Please,
appeal
please,
list. For hearing after 3 weeks?
please.
Only a date may be fixed. ma'am.
Yes.
For final hearing minutes.
When hearing. 13th. In November. 13th of November.
Publish.
My lords, could it be 14th, my lords?
14th. Yes.
Please.
Government advocate.
For 2 weeks' time, my lord, we'll take necessary steps to.
80 days in filing LR application. Deceased R1. Notice has to go?
Notices,
Has to
I-
go?
notices.
Yes. Notice in the IS. The staff to service is complete.
27, Kiran BS.
I represent for appellant in the home matter, my lord. I seek short accommodation, my lord.
Sorry?
6 months.
Who appears for the?
Number
Appellant, I represent
27.
for appellant. 27, my lord, I represent for appellant in the above matter, my lord.
What are the
So I-
office objections?
Office objection is regarding to filing of written submissions by the respondent side, my lord. We have complied with the office objection. So I request, my lord, I have engaged a senior counsel on this matter. I request a date to be given, my lord. November 13th may be given, my lord, please.
What do you say?
So far as I am concerned, well, I filed my written submissions. In the previous occasion where it was supposed to be listed in final hearing, for final hearing.
Has everybody given their written
I am the
submissions? You have.
Yes,
They
madam.
also filed.
Respondent number 4, I am filing, madam.
You're filing it today.
Today, next date.
The fourth respondent seeks a short accommodation to file the written objections. Week's time granted. List on 1311.
Grateful,
1311.
grateful, my lord.
Please.
28. Indramurti.
All the office objections have been cleared. My lords have passed an order on the last hearing that no need for any translation.
Yes.
From the respondent number 2. The report has been filed, I am filing an application.
Yes.
Have you given the copy?
Copies have been served?
No, if he is filing it today, I'm not sure.
File it in the registry. Please file it in the registry council so that all the Can let it be? Yes. Signatures are there? Yes, it is submitted that an objection is being filed by the appellant to the comprehensive report filed by the additional government advocate with copies being served on the part, on all the, on the council appearing for all the parties.
That has to be argued along with merits, madam.
That we'll consider on the merits.
He didn't give me a copy either.
Please serve it on, please file it in the registry. All other applications to be filed in the registry. List on,
He wants to file an application and he wants to argue it.
weeks. List after 2 weeks.
811.
1 week may not be possible, Council. Yes,
That does it.
29.
please see that copies are served and filed properly. Yes. 29. To delete the name of advocate for R1.
My lord, for the appellant, the R1 counsel undertook to appear. But then on the same day, it appears that he had some,
A memo has been filed on 16/12/22 to
so on the
delete the
same
name
day,
of
on
R1.
the very same day that he agreed to take notice before the court. Appears to have filed a memo saying he wants to withdraw.
Has taken the entire file in the above said petition and the undersigned counsels are disabled from representing. You'll have to accept that. You'll have to accept.
I am not on.
Yes. The memo dated 16/12/2022. Filed by the council. Shown to be appearing for R1 is accepted. The and the name of the counsel for R1 shall stand deleted from the cause list. The further objection with regard to non-filing of acknowledgement for serving copy of the appeal on the advocate appearing for R1 is therefore overruled.
In the meantime, my lord, notice has gone through the court. I mean, I took out process that has been served on the respondent. Also, what was sent by the court has also been served.
R1 is already served, which is why the advocate. That is the memo. The party came and took all the files. That is the memo. Do you want further notice can be issued?
My lord, may I clarify that? We took out.
Let
no,
one,
that's okay.
one round of notice go to the party, because otherwise, ultimately, it may land on the council who had appeared.
No, it's
because
not
there
that.
is-
May I just, that's a clarification I want to make. Through, the process was served on him. Thereafter, based on the memo filed, the court ordered notice. So a court
Further,
notice has.
further notice
yes,
is gone.
Court
When
notice
was
has.
that?
That was about 2 or 3 dates back. And that also has been served.
Then IA number 2 of 2022 is allowed. Third learned counsel for the appellant issue notice. Is also permitted to serve a copy of the writ appeal on so and so learned counsel appearing. Then notice has not gone thereafter.
No, court has
Just a
ordered.
moment, just a moment, just a moment. Appeared through video conference, accepted notice for R1. Seeking to stay operation, so and so made out a case for interim order, argue points. Undertakes to serve a copy of the appeal. When was the notice sent? List appeal after 2 weeks. Who appears in memo dated by made in notice. Court notice be issued to the respondent. Yes, it has gone. 26/7/24 it is gone. When was notice taken out? 12/8, probably is after that. That has been served. Notice is served. Copy of order dated sent to so and so. Yes, we noticed that on the memo filed on 16/12/2022, notice has been taken out to the respondent on 23, has been taken out to the respondent and has been duly served on 12/8. 12/8 and thereafter 12/8 service of notice is recorded by order dated 23/9/2024. In the above view of the matter, the memo dated 16/12/22 is accepted. The name of the council is deleted from the cause list. Interim order is already there. Interim order is already there.
There is an, on 16/12/22 interim orders.
List, maybe after 3 weeks. List after 3 weeks.
Chandrakant Argole.
For appellant matters, the advocate appearing for respondent number 2 to 4 said that he will be filing a wakalat for the rest of the respondent also. He will take the information and then we will take a steps, my lords. 2 weeks time may be granted.
Yes, at the request of the learned counsel for the appellant. This case after 2 weeks.
31, K. Krishna.
And for respondent.
Yes.
We permitted.
Written submission along with judgments.
We have to file a synopsis, my lord. I pray 1 week's time, my lord.
And the judgments as well
Yes,
that you're
ma'am.
relying on. So we can list it for hearing after 2 weeks.
In
Please,
meantime, we will
the
file it
learned counsel for the appellant is filing written submissions along with judgments today. The same is taken on record. Learned counsel for the respondent seeks a week's time. Week's time granted, file it within the week.
Weeks, ma'am.
Yes. List for consideration after 2 weeks. Give a convenient date.
1911.
Obliged.
Please be ready on that.
Please, madam.
32, Harish N.
My objections are ready.
I'll be filing the objections in the registry today. I've already served the
You're
copies.
objecting to the impleading?
Impleading application.
Let us.
I have not filed the impleading application. I am for the.
Somebody else is filed.
Somebody else is trying to.
I am for the impleading applicant.
impede it.
What, is there any urgency in this matter?
No, madam, it's
Urgent.
Let the objections be on record. We list it after 2 weeks.
Yes, please.
33, Naikana,
Much obliged.
or 6.
PPF, weeks time. Weeks time to comply.
34, Girishavi,
Signature in the memo for dismissal. Yes, weeks time.
35, Kumbar
Okay.
Shivuputrappa
33, my lord.
Petition.
33, my lord. I am going to withdraw that petition. Except one IA I have filed, my lord, for extension of time to submit the application before the concerned authority, my lord.
Yes,
That is
you're
only
withdrawing,
extension
withdrawing
time I
which
have
memo?
requested, my lord. Serial number 33, my lord. IA I have filed.
33 or the,
To submit the application for registration, your
yes,
lord.
do whatever you want within a week.
Please, my
A
lord.
week's time is granted. Yes,
Please, my lord.
for petitioner for serial 35. 35. Furnishing PF, correct acknowledgement, correct address.
Yeah, praise for time, like, to
Please do
comply.
it immediately. Week's time granted as sought for. To comply with the office objections.
6, Ajay Kumar Patil,
Translated copy of Annexure G. What is this education? 2023 writ petition.
That's actually one of the last year's, previous year's
Does anything survive?
admission, it has become actually not infractuous. He's not in the country, my lord. That is what the submission made in the other court. The counsel for the petition.
Counsel. So shall we list it on another day?
Yes.
As a last chance?
Yes.
Without him being in the country, we
Yes,
don't want
that's
to
the reason.
dismiss a writ petition. Yes, list. Give a listing in the matter.
37, Chetan DT,
ಮೇಡಮ್ ಲಾಯರ್ ಅವರು ಬಂದಿಲ್ಲ.
These are the notations.
ಮೈಲಾಡ್
Notice. Notice as to.
ಬೈ ಹ್ಯಾಂಡ್ ನೋಟಿಸ್ ಬೈ ಹ್ಯಾಂಡ್ ನೋಟಿಸ್ ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಅನ್ನೋರಿಗೆ ಬಂದಿಲ್ಲ ಮೇಡಮ್.
Please ask him to file the PF, provide the PF.
Service ಆಗಿಲ್ಲ, PF ಎಲ್ಲ ಕೊಡ್ಬೇಕು.
ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಬೈ ಹ್ಯಾಂಡ್ ಮೇಡಮ್.
And he wants to take.
ಮೇಡಮ್ ಮೇಡಮ್
In addition, first you pay the process. Ask him to pay the process.
ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿ ಇನ್ ಅಡಿಷನ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ. 2 ತರನು ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ನೋಟಿಸ್
PF ಕಟ್ಟಿ ನೋಟಿಸ್, ನಾರ್ಮಲ್ ನೋಟಿಸ್.
ಓಕೆ
ಇನ್ ಅಡಿಷನ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
ಬೈ ಹ್ಯಾಂಡ್ ಕೊಡ್ಬೋದು.
ಬೈ ಹ್ಯಾಂಡು ಕೊಡಿ, 2 ಆಪ್ಷನ್ ಕೊಡ್ತೀವಿ. ಆದ್ರೆ ಕೋರ್ಟ್ ಮೂಲಕನೂ ಹೋಗ್ಬೇಕು. ಗೊತ್ತಾಯ್ತಾ? PF ಕಟ್ಟಿ. ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿ ಮಾಡ್ತಾರೆ.
Yes, week's time granted. The petitioner is also permitted, appellant is also permitted to take out notice to the respondent by hand service. Tell him that he has to pay the process anyway. Yes, list after services.
ಕೌಂಟರ್ ಅಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಕಟ್ಬೇಕು. ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿ.
1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದೆ, ಎಷ್ಟೊಳಗೆ ಕಟ್ಟಬೇಕು?
1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. 38,
2024 office objection.
Complaint before court, but it has not been recorded, that's it. Only translation
Right.
copy. You already filed with the memo.
Yes,
Well, I'm filing the statement, but
I'll just go through it, madam. We have next week.
next week.
shall I file it in the office, madam? Counter I'll file.
By the way, if copy has been served, it can be filed here. Copies have been served.
Copies are just now.
I have received the copy.
Yes. The counsel for the respondent EA has correspond number 3.
R3.
R3. R3 places a statement on record. Copies have been served. to the writ petitioner as well as the government advocate for R1 and 2. List next week.
Please.
It is submitted by the learned counsel for the petitioner that the office objections stand complied with. Said submission is recorded. This next week. 39. Monisha?
For the statement.
Yes.
Interim direction for admission of this petitioner in respondent number 7.
Hmm.
In the meanwhile, my lord, only prayer is, but respondent number 7 has not admitted because there was no direction by the R3. I pray that the learned standing councils be directed to take notice. I will serve on them.
There is standing counsel for R7 as well.
Kitty for R2, my lord.
R7, they have to serve it on the college itself. There's no standing.
R7 will be directed to serve personally, my lords.
Yes.
R6, R7.
R6 and 7 will serve, my lords. Number one learned council is 2, 3, 4, 5 learned advocate Ramesh for
4, I think.
4.
Yeah.
4. 2 and 3 Kitty.
1 and 3, state will take notice.
and
Yes, learned government advocate takes notice for R1 and 3. Then
Serial number
2,
2, Mr. Katie will take notice. Below.
Mr. N. Keti, my lord.
yes. 2 so will takes.
4,
petition
Lord,
to
I'll
serve
take note.
notice on so and so learned panel council for R2.
4, I'll take.
So,
RGHS, sorry.
Sri
Five.
N.K. Ramesh learned council takes notice for R4.
R4, my lord.
Only 4.
Only 4.
What about 5?
Raju Gandhi. Any standing council.
Really?
Sachin BS. Sachin BS.
Learned counsel for the petitioner shall serve notice on R5 through his counsel so and so. Then
6 and 7, my lord, may be permitted to personally serve on them, my lord.
6 and 7. Yes,
And my lord,
it was already ordered. You have not taken notice.
we will. 6 and 7.
Notice was already ordered to all the respondents. 6
Please.
and 7 should have been, the process should have been paid by now, not done.
We will.
Yes.
My
R6
lord,
and
one
7.
humble submission, my lord, the direction,
Hmm.
earlier one college, my lord, was closed, recognition was cancelled, my lord, therefore they were shifted to one college.
Hmm.
Their fees was very high and therefore they could not afford, my lord. So R7 came forward and said, we will admit.
Hmm.
And based on that, this one court directed
Hmm.
that you pay the fees with R7. Now, my lord,
7 has not been served. Senior counsel.
please, they have given the, we will,
Acting counsel, please see that R7 is served.
please, my lord,
All this
I will.
could have been done. And in
Please.
the meanwhile, process could have been paid for at least R6 and R7.
My
It's
lord,
not been done.
we'll do it, my lords. You know, only
By
R7 has no problem.
additionally by hand
Yes.
service or however you can serve, please serve
My
it.
lord,
Unless they come here.
please.
we
Now, my
can
lord, only
proceed
problem
further with
is
this matter.
R3,
Hmm.
R3,
Hmm.
R7 says,
Hmm.
we want a letter by R3. That is the problem, my lords. R7 is ready to,
Let R7 come here. And then if that is required, then we can pass further orders. Unless R7 comes here,
please.
we are proceeding on your submission that R7 said so.
We have produced a letter of R7, my lords, already on record, my lords. Page 16, annexure D, letter by R7, my lord, stating that we are ready to admit, etc.
Government advocate, please get instructions on that.
R3,
Lord,
my lord, state,
On the
Please
face of
get
it, we have
instructions.
no objections, my lord. We had only prescribed a cap which could not have been exceeded
Hmm.
by the colleges.
Hmm.
If any college is willing to
Accommodate you.
take
don't-
lesser fees, then we have no objections to.
So therefore, they say that they require some kind of an acknowledgement from you.
But that kind of acknowledgement
Please see,
will not be given. But we have no objections. I'll do the needful. I'll ask them to issue an.
yes, so
Please.
let R7 come here.
as well,
Once R7 appears, we can
please.
rectify, dispose of the matter itself.
Please, ma'am.
Yes, that could
End of
be.
it.
Yes.
Let R7 appear so that we can dispose of the matter itself.
Please.
If required, say that R3 does not have any
Yeah.
objection, we can record that
Correct.
and the matter itself can be disposed of.
That can be done, my lord.
Please take out notice to R7 by
We will.
whatever means you want.
Please, may I pray for an earliest date possible? I will, in 2 days, we will ask. Because the admission has to happen. Now the examination is coming, my lord. This Saturday. I would be humbly obliged if you lords accommodate on this Saturday, my lords.
Saturday.
Working.
Not a working day for
26.
High Court.
High Court.
Not for the High
I
Court.
thought, then Monday.
Oh, good news.
Yes, once it is served, you can please seek a date.
Please,
serve the notice on R7 and seek a date, we'll list it.
Please, there's one more matter, my lord. A similar question is involved, my lords, of the students who are also seeking admission in the same college. College has no objection, my lords. We had moved the matter, but since in that case, my lord, the date is already fixed for, original date is fixed for November 4th, my lords. The registry has not, my lords.
Then we can list this also on November 4th.
That becomes very late for this reason, my lord. Examination as 13th is the examination, my lord. Therefore, my prayer is, my lord, we have moved the matter.
Can we make an attempt to list this on Friday then?
Please.
Meanwhile, will you see that
We will.
it's served and the council is here?
Please.
Friday.
Friday, and along with the other matter, which.
Give the numbers also. Give the number of the other matter also. Let's see.
Grateful, most grateful.
Passed over matters. Bill number 7, Sampath.
Passed over serial number 7.
Number 12, M. Rajshekar.
Yes.
Records are ordered to be secured.
Hmm.
Fund has to produce.
The records are here.
Yeah, but Fund has to secure.
They're available.
Not yet received the records.
Okay.
I've received the.
That one set it was received. At my request, my lord, that one more register is to be called for.
Hmm.
Lordship has directed to call for that register, that it has not.
What my learned
Wait,
friend says is there are two sets of records, my lord. That is, I don't know, but they had brought one set. So let them bring the entire set, my lords. Without the records, nothing can. The subject is only 15 guntas, my lords.
That was the only question.
Yes,
Please,
that
my lord.
It is
is.
15
Whether
guntas or
she is
45
entitled
guntas.
to 50
whether
or
I am
45. That's
45.
it.
Is the
That
only
is the subject matter, my lords.
Learned Government Advocate seeks further time to verify the records received and also to get records with regard to the enhancement of the land granted to the respondent number 4 as 1 acre 5 guntas.
Yes,
Please, my lords, please.
that the another register was produced before the land single judge. So that register was not produced, secured, that if it is secured, my lord, that we will address all.
The Learned Government Advocate seeks further time to make available the further records, if any, with regard to enhancement of the land granted to respondent number 4. List. When shall we list this?
But,
Please
next
give
Wed-
a realistic date so that
next
we have
Wednesday.
to be here. Next Wednesday.
30th.
Next Wednesday, but in the meanwhile, the records will be available.
I'll secure.
Yes. Only half days. Okay. So can we list this in the week after?
Please, my lords.
Please, my lord, that after 4th or 5th, any day.
That if the records are available on Wednesday, probably
Please.
the
6th
Government
November.
Advocate will also get time to
6th.
verify those records.
Obliged,
6/11.
obliged.
14, B. Vachan.
My lord, I may be permitted to start, my lord, because every time,
He's very much here
yeah, I'm sorry,
and very much ready to start.
I'm sorry.
Yes. Only 2 appeals,
2 appeals, my lord.
both by the BDA.
One is from BDA.
Second is by BBMP.
The BBMP was not a party before the learned single judge. However, affected by the order passed by the learned single judge, with liberty of your lordships, appeal has been filed.
Yes.
Lordship may kindly take the synopsis that I have filed.
Yes. This is 119. List of citations.
I
Yes.
mentioned the page numbers also, my lords. On the layout in question is Banashankari first stage, my lords. On 27/11/1959, preliminary notification was issued.
27/11.
1959. Two survey numbers in question, my lords. Survey number 32/1, measuring 3 acres 10 guntas. And 32/2, measuring 1 acre 20 guntas, totally measuring 4 acre 30 guntas. However, the petition schedule measurements are limited to 16,100 square feet.
16,000
100 square feet.
square
Feet.
feet. Yes.
Final notification, my lord, on 22/4/1964. Page number 72, relevant entry at page 78, my lord.
Yes.
On 6/7/1966, my lord,
Hmm.
the father of the respondents 2 to 12,
Hmm.
before I say that, my lord may kindly come to page 488, second volume,
488
488 minutes.
of the
My request, my lords, of the second volume, my lord, petition book, second volume.
second,
My request, lordship.
488.
I'm sorry, my lord, 469, my lords.
Hmm.
Lordships will find a memo.
Hmm.
This memo, my lord, is a withdrawal of the petition in which, my lords, there's a batch of petitions filed challenging the acquisition. One of the petition was filed by the father of the respondents 2 to 12. That petition number, my lords, will find at page 471.
Hmm.
WP number 554 of 1965, TV Venkata Rao is the petitioner.
554.
554 of 1965, the second from the top, my lords.
Yes.
I'll read the memo, my lords. In view of the undertaking given by the second respondent CITB in their memo dated 27/6/1966 filed before this honorable court, the second respondent board will implement the resolution dated 18/7/1962 in favor of the petitioners shown in the list annexed to the said memo,
Yes.
and the statement made in para 7 of the second respondent's counter affidavit to the same effect. The petitioners in the undermentioned case beg leave of the court to withdraw their petitions with liberty to approach court again in the event second respondent failing to implement the said undertaking. My lord, the undertaking pertain to
Hmm.
a resolution, my lords, will find at page 488.
Hmm.
This is the resolution, my lords, the memo refers to.
Hmm.
I request my lords to come to page 488. The typed copies at 489.
Hmm.
This is the annexure which I filed it with my affidavit.
Hmm.
This resolution dated 18/7/1962, my lord,
Hmm.
talks about the areas
Hmm.
which are built up and therefore may have to be considered for reconveyance.
Hmm.
My lord, the survey numbers in question is private layout in survey number 7, 8, 9, 11, 22, 23, 24, 27, 33 to 41 of Gavipura village.
Hmm.
Lordships may kindly note that the survey numbers in question before your lordships does not form part of the resolution. So there is no reconveyance scheme as such for the said survey numbers. That's the first point. The second point I would like to request your lordships to kindly take note of is, as your lordship sees the second half of the page, there are several points, 1 to 5. The fifth point may kindly be seen. The area shown as parks, playgrounds, CA would be civic community, my lord, in the City Improvement Trust Board plan will not be reconveyed. Lordships may kindly note this particular point because the 16,100 square feet of land has been earmarked as a civic community site in my sanction plan. Therefore, my lords, even though this said subject survey numbers were not part of any reconveyance scheme, the father of the respondents 2 to 12 chose to withdraw the petition, my lord. There, the challenge to the acquisition stopped. My respectful submission is challenge to the acquisition stopped. So in my first instance, I'd argued the matter, my lord, saying that when the father withdraws the petition or fails to challenge the petition acquisition, the children under section 8 are not permitted to challenge the acquisition. I had argued then on that day I had made a mistake by saying that there was no challenge. I stand corrected. There was a challenge in fact, but however, the petition was withdrawn. There's no representation from my end that I'll reconvey the land with respect to these survey numbers, but the petition stood withdrawn, my lord. That fact of withdrawal remains to this day. There's nothing else that they have done about it, about this said withdrawal. Now, my lords may kindly come to my synopsis. On 8/5/1967, my lords, I passed two separate awards for these two survey numbers. Lordships will find the awards at page 356 and 344. Again, volume 2, if I may kindly request, my lords, I would like to point out something in this.
The 6 and
356 and 344. May I request lordship to kindly come to 344. 32/2 award copy, my lords.
total acre, it's 1 acre 20.
1 acre 20 guntas. Award has been passed. Lordship may kindly again come to 356.
344 is on 7/5/64.
Gazetted on 7/5/1964. Declaration on 22/4/1964. I'm sorry, my lord, I stand correct. I'm sorry, my lord, the FN date, I must have mixed up the date. 7/5/1964 is the award.
Yes.
On 356 also, your lordships will find the award for the other survey number. 356. 32/1, 3 acre 10 guntas. Lordship may kindly come to page 358.
The great.
Also 7/5/64.
Yes, 7/5/64. At page 358, at serial number 4, lordships will find the name of the father of the respondents 2 to 12. M. Venkata Rao. However, the persons mentioned below, my lords.
Yes.
However, the persons mentioned below have filed their claim applications in this case on the date noted against their names. Lordship may kindly appreciate this. It seems as though the said Venkata Rao has formed revenue sites in these two survey numbers and had already conveyed it. So all those persons who had purchased site in these two survey numbers came before the acquisition officer and file their objections, lordships will find their names until page 360 till serial number 46. Again, my lord, notices under section 11 and 14, lordships will find objections filed from serial number 1 on page 360 to serial number 55 at page 362. Why, my lords, I am saying this is because the reason as to why the extent of the land in this petition stands reduced from 4 acre 30 guntas to 16,100 square feet is the balance land have been sold by them. And my lords, as far as the lands other than the 16,100 square feet, the respondents 2 to 12, by virtue of not challenging the acquisition, have deemed to have accepted the acquisition. That then automatically, my lord, a question would arise whether a landowner is permitted to challenge the acquisition in part when he has accepted the other part, when my action of passing an award, evaluating the property, and taking over possession or depositing of the compensation is not challenged for the other part. How can a portion of the land be subject matter of petition? That is why this becomes relevant, my lord. Another point, my lords, what I would like to place before your lordships is because the last state of hearing, it was sought to be put forth before your lordships that much of our land has been taken. We are only left with a limited parcel of land. Kindly let go of the land. This was possibly the argument which I thought I understood. That's how I understood. So I want to place before your lordships that's not the case. It alienated the lands. What was left, they think.
Entire land was, as a matter of fact, acquired.
Yes, my lords.
Attention is that with regard to the other land, there were other claimants in respect of sales conducted by the owners of the land, and therefore what is left in the, what was left in the acquired land in the names of the petitioners was only the 16,000 square feet.
May I submit it like this, my lords? What they think they have not conveyed it by way of a revenue site.
Correct.
They intend to now challenge it in acquisition. But I have acquired the entire extent. I don't draw a distinction between 16,100 square feet and the balance land. They intend to seek a lordship may kindly come to synopsis, page 2, my lords.
Yes.
On 14,667, my lords, I take possession by way of two separate mahajars, 387 and page 350 of the second volume, my lords. Amount deposited in the city civil court, my lords, on 30/3/1968.
Because there are other claimants.
There are other claimants. The award copy, my lord, the land acquisition officer, my lord, notes, because there are so many other claimants, we have no choice but to deposit it in the civil court.
Yes, we've seen that.
Yes, my lords. Now, one of the contention before the learned single judge was that I have not placed any material before the learned single judge to show that I have deposited the amount. May I kindly request, my lord, to come to the first volume, if I may kindly request. Page 264. I'm sorry, my lord, I'm requesting your lordships to change one volume to the other.
Yes.
264, if I may kindly request.
Yes.
My lord, I filed a translation at page 265. The translation is slightly wanting in its quality.
Yes.
I'm so sorry about it. But what has happened here, my lord, is that this is a document produced by the respondents 2 to 12. They filed an application under the RTI Act to the BDA asking us whether we have paid the compensation and taken possession of the property. In response to it, we have written a response. In this, my lord, we say at line number in the response column, we say that on 14/6/1967, we have taken possession, and on 30/3/1968, for survey number 32/1, we have paid a sum of rupees 16,430 in the city civil court by check number 7375. And as with respect to survey number 32/2, on 30/3/1968, we have paid a sum of rupees 7,503. I give this information to the respondents 2 to 12. Possibly this is not brought to the notice of the learned single judge from our side. Possibly it's our mistake. But the fact remains, my lord, they themselves are aware of the fact. Now whether they withdrawn that amount or not, we are not aware, my lords. Could not have been done because so many sites had already been sold. That could be the reason, my lord. So I take possession, I pay the compensation. Subsequent to I'll show the possession also, my lord, for a moment. Lordship may kindly come to second volume, page 387 and 350. Page 383, the vernacular version, my lords. I take possession by way of a Mahajar, my lords. 386 is survey number 32/1 and 350, my lords, is survey number 32/2. The translated version is at page number 354. So my lords, the acquisition was complete way back in the year 1967.
Yes.
The first challenge to acquisition is in the year 2016. Delay and latches, my lords, I'll address it. But if I may say this, my lords, the respondents 2 to 12 were not quite. They were absolutely not quite. They litigated upon it in an indirect manner, in such a manner that the allottee of the site was unable to enjoy the property. Now, why I say this is this because on Lordship may kindly come back to the synopsis, serial number 7, on 14/8/1980, petition land was leased in favor of one Sonar Yuvaka Sangha on wide registered lease agreement, page 149. Now, for a moment, I'd like to pause here, say this. The very fact, my lords, that I have gone ahead and allotted the site to some Sangha means, my lord, the site has been formed, the scheme layout has been formed, the scheme has been implemented. The learned single judge, my lords, would not have possibly come to a conclusion in light of this document that I have not formed the scheme or not formed the. The very fact that I have allotted. It might be another matter, my lords, that this allotment in favor of the Sonar Yuvaka Sangha came to be cancelled 24 years later for reasons which are unconnected with the acquisition, but the fact remains that I did the allotment. Now, my lord, what happened was that once I allot the land in the year 1980, a public interest litigation is filed with respect to this land. Now, my lords, the reference to this public interest litigation is found in, my lords, the document at page number 184. May I kindly request Lordship to come to page 184. Yes, my lords. What this Sonar Yuvaka Sangha does is, my lords, the Sonar Yuvaka Sangha does not use the land for which purpose it was given. So we issued a show cause notice asking them, why should not the allotment be cancelled? That notice, my lords, is questioned before this honorable court. Kindly see, my lords, what is noted in this order copy.
Yes.
Page 186, my lord, para 2. The matrix of the case is the petitioner is a registered trust in the name of so and so, which was established in the year 1978, having its office at so and so. Suffice it to say that the petitioners applied for civic community site in Banshankari first stage. The first respondent, having regard to the objects of the trust, granted civic community site number 10 of Banshankari first stage, at measuring 115 feet into north to south 140 feet. That is 16,100 square feet. The exact same site which, my lords, is in petition for your lordships. The said lease was registered, a copy of which is produced as Annexure C. The petitioner Sangha had planned to construct a Kalyana Mandapa to establish a divine school of spiritual studies to provide education, library, and accommodation with the sole objective of enriching Hindu heritage and culture, and especially to enlighten the divine teachings of Vedanta, Upanishad, etc. It appears the petitioner Sangha also proposed to construct temples of so and so deities it appears the respondent BDA permitted the petitioner to put up a construction. The said sanction plan was in the year 84. The case of the Sangha is that it had already invested a sum of rupees 10 lakh in putting up a Kalyana Mandapa. But however, a public interest litigation was filed in WP 10642 of 86 on the ground that the lease in favor of the petitioner is to be annulled on various grounds as asserted in the writ petition. The said writ petition, which was filed in the year 1986, eventually was disposed of in the year 95. Indeed, this court declined to entertain the petition on various grounds apart from latches. Thus, the petitioner was before this court for a period of 10 years. After 96, it's the case of the petitioner that they start collecting funds and so on and so forth. Now, my lords, that was the first public interest litigation with respect to this particular land. It was not a general public interest litigation. It concentrated on the 16,100 square feet, concentrated on the allotment made in favor of the Sonar Yoka Sangha. Therefore, the development could not be done. I do not want to say whether the stand of Sonar Yoka Sangha is right or not. I am also not in a position, my lords, for a moment to say that they got the public interest litigation done because there's no such material on this effect. But for some reason, my lords, if I may to say this, the benefit of it seems to be going to them. Now, my lords, this petition, my lords, was disposed of. Lordship may kindly come to page 192.
Yes.
Petition stands allowed. The impugned order at Annex Sherry stands quashed. The matter stands remitted to BDA for fresh disposal in accordance with law, my lords. Now, subsequently, my lords, the BDA passed an order annulling the lease agreement, and the Sonar Yavaka Sangha chose not to contest the annulment, and so there ended the allotment bidding for Sonar Yavaka Sangha. Subsequently, my lord, this same CS site was allotted in favor of one PAS educational institution for setting up their college. Lordship may kindly come to the lease agreement at page number 197, document number 10. Lease agreement of lease dated so and so between People's Education Society so and so, represented by so and so by the Bangalore Development Authority. Lordship may kindly come to the schedule, page 204. I would request your lordships to kindly see the boundaries. East by road, west by CS site, north by CS site, south by road. So this entire area, my lord, CS sites have been carved out. The same measurement, 115 feet by so and so, which comes to 60,100 square feet. Now, my lords, when I do this, my lords, a second public interest litigation is filed before this honorable court, again saying that the allotment has been done in violation of the rules, my lord. Pursuant to this public interest litigation, my lords, I proceed to cancel the allotment made in favor of PAS Educational Society. Lordship will find the order copy, the translated copy at page 218. By one, TM Sridhar challenges the allotment. Kindly come to page 219. TM Sridhar has questioned allotment of site as per WP number 20032 of 11 in Honorable High Court in PIL. In the said application, appeal to provide direction since said allotment is not as per the rules. So therefore, my lord, I again proceed to cancel the allotment. Whether I had followed the rules or not, my lord, the fact remains, my lords, that I was trying to exercise my title rights over the property. The reason why I'm stressing this, my lords, is that the conclusion of the learned single judge that I have neither taken possession, nor I have deposited, the scheme not implemented, my lord, all are absolutely contrary to the records. And all these were placed before the learned single judge. Possibly we have not brought it to his notice, my respectful submission.
Yes.
Well, subsequently, my lord, Lordship may kindly come to synopsis at page 3, my lord. They said subsequent to my cancellation, my lord, the writ petition was also disposed of as infructuous. Lordships may kindly come to page 3, serial number 18. WP number 45314 of 2011 to 46661 of 270 filed by respondents 2 to 12 seeking mandamus for reconveyance of the petition land by representation dated 4/11/2011. I want to make a submission here. Once the landowner seeks reconveyance of the land, it's an acceptance of the acquisition. They sought a mandamus. This mandamus, my lord, was allowed, directing the BDA, my lords, to consider the representation for reconveyance. Now, my lord, this was brought in an appeal before your lordships. Now, lordships may kindly see this order. I'm sorry, my lord, it's not part of the synopsis.
Yes.
Lordships may kindly come to page 3.
Hmm.
The same respondents 2 to 12, my lords. Page 3, the writ petition numbers are the same numbers: 45314 2011, 44661 670 of 2011. These readable, I'll read this entirely, my lords, because this would lay at rest many of the controversies.
Yes.
These writ appeals are preferred against the order of the learned single judge who was declined to entertain the writ petition where he has sought for a direction to reconvey the property bearing number 1, situated so and so, measuring an extent of 115 to 140, same land. The material on record discloses the appellant was the owner of the property bearing number 32/1, measuring to an extent of 3 acre 10 guntas, and 32/2, measuring 1 acre 20 guntas, situated and so on. It was acquired for formation of layout in the southern side of Mount Joy. The preliminary notification was issued on 22/4/1964, final notification on 29/5/67, award on 14/6/67. Compensation amount was deposited before the civil court on 11/6/68, and on the same date itself, possession was taken, layout is formed. It is nearly 40 years thereafter. The writ petition is filed on 2/12/2011, claiming reconveyance of a portion of the land which was owned by them, which was subject matter of allotment on the ground that notwithstanding the said acquisition, the petitioner is in possession of the land and continues to enjoy the same. This contention may kindly be taken note of, because that's the same contention as it has been done here. The said request has been rejected by the learned single judge on the ground. Firstly, there's a lapse of 40 years in approaching the court. Secondly, the site in question is a civic community site, and there's no obligation on the part of the BDA to consider the representation filed 40 years after the final conclusion of the acquisition proceedings. Learned counsel for the appellants assailing the impugned order contends that they have been in peaceful possession and enjoyment of the site in question, and it is not a civic community site. No documents are produced to show it is a civic community site. Reconveyance of adjoining site has been done in the year 2009-10, and the Revenue Authority has also issued assessment register extract for the said period. We do not see any substance in the said contention. In the first place, when the possession of the land has been taken, was taken after passing of the award in the year 1968, the said land vested with the government, free from all encumbrances. But in spite of the land vesting with the government, if the appellant still contends that he continues to be in possession and enjoying the property, that by itself would not give him a right to seek for reconveyance. After the amendment of the BD Act, substantiate provision is made for reconveyance only if those conditions are fulfilled. Then only the question of considering the request and granting reconveyance does arise. From the material on record, it's clear that the said requirements of reconveyance are not complied with. An acquisition which has become final 4 decades back is sought to be revoked. It's a settled law that things are settled long back by courts, in particular in excess of its jurisdiction on Article 226 of the Constitution of India, cannot again be looked into. In that view of the matter, learned single judge was justified in rejecting the writ petition. We do not see any merit in these appeals, and accordingly they are dismissed. So there are 2 pending applications are also dismissed. Now, the very same land, my lord, the very same parties don't disclose this before the learned single judge. To my understanding, my lord, this order has not been set aside by the Honorable Supreme Court. This has attained finality. Finding on fact and finding in law, my lords, unassailed. We also ought to have placed it for the consideration of the learned single judge. We have not done it, my lords. Very sorry for that. I happened to chance upon it because the termination of the CA in the second instance, allotment of the CA said in the second instance, in that notice, the writ petition number has been stated. So when I looked into the writ petition number and tried to find out from the writ appeal, I saw that matter has attained finality.
Yes.
No, my lords, when things stood thus, when matter attained finality in 2013, my lords, 3 years later, from a point of where they are seeking reconveyance, they filed this instant petition challenging the acquisition.
Yes.
Now, they want to, my lord, say that they are in possession of the property and that the BBMP has registered khata in their favor. That they want to make a base as an argument to say that they are in possession of the property. Notwithstanding the fact, my lords, the division bench of this honorable court says, refuses to recognize their position because the same argument that I'm in possession has been refused by this honorable court. Now, my lord, what I have done is that now for the third time, I have leased this land. I have given this land to BBMP, my lords, so that serial number 24 may kindly be seen in the synopsis. BBMP intends to, my lord, the reason why BBMP is before your lordships is that they now intend to allot this land to so and so for setting up a public hospital on a public-private partnership basis. Now, at this juncture, my lords, they now seek to wrest the land back into their hands. A few citations I'd like to take your lordships through. The first is the Indore Development Authority. Lordships would have seen it many times. There's a few paragraphs, my lords. May kindly request your lordships to come to page 240, para 246, my lords, at sorry, my lord. Page number. Page number 201, my lord. This is on just a pure point of law, my lords. Even since they have already sought for reconveyance, may not be, my lords, if I may say this, incumbent upon your lordships to answer the query because they sought for reconveyance. But since the learned single judge has given a finding that possession has not been taken, I am citing this, my lord. Para 247, my lords.
Yes.
The question which arises whether there's any difference between taking possession under the 1894 Act and the expression physical possession under in section 24.2. As a matter of fact, what was contemplated under the 1894 Act by taking possession meant only physical possession of the land. Taking over the possession under the 13 Act always amounted to taking over physical possession of the land. When the state government acquires land and draws up a memorandum of taking possession, that amounts to taking the physical possession of the land. On the large chunk of property or otherwise which is acquired, the government is not supposed to put some other person or the police force in possession to retain it and start cultivating it till the land is used by it for the purpose for which it has been acquired. The government is not supposed to start residing or to physically occupy it once possession has been taken by drawing the inquest proceedings for obtaining possession thereof. Thereafter, if any further retaining of land or any re-entry is made on the land, or someone starts cultivation on the open land or starts residing in the outhouse, etc., is deemed to be a trespasser on land which is in possession of the state. The possession of trespasser always inures to the benefit of the real owner, that is the state government in the case. So at best, my lords, even if they want to argue, my lords, that there's a khata registered in their name, my lords, at best, they can only be considered as a trespasser, my lords, not anyone beyond, anything beyond it. Para 251, my lords, just a few paragraphs, my lords.
Yes.
Respect to possession. One who enters or remains in possession on land of another without a privilege to do so is also treated as a trespasser. On the strength of the full bench judgment of the Patna High Court, Mitra has referred to the observation that the possession should not be confused with occupation. There's a distinction being drawn. He can occupy the property, but he is not a possessor of the property.
Yes.
A person may be in actual possession of the property without occupying it for a considerable time. The person who has a right to utilize the whole in any way he likes possession in part is good enough to infer that the possession is in person is in possession of the rest. Now, why, my lord, this line is important is because me taking possession of the balance land is not in question, is not in dispute. They admit to it, they agree to it, because they limit their challenge to 16,100. If that is so, if my possession of the rest is not in dispute, then my possession with respect to 16,100 also cannot be disputed much.
Yes. Yes.
I'm sorry, my lord, I'll just say that. This as far as possession is concerned, my lord, the same judgment,
Yes.
I'll also refer to delay and latches because the challenge is in there 16.
Yes.
Lordship may kindly come to page number 264, my lords. Ink page 264. Page 351. Page Nara 352, if I may kindly request your lordships to see. Page ink page 264, print page 386.
Yes.
Para 352.
Hmm.
There's a plethora of decisions where, owing to delay of 6 months or more, this court has repelled the challenge to the acquisition proceedings. Even 6 months, my lords. Here we are looking at 60 years.
Yes.
Page 354, I'm sorry, para 354. In Dharappa versus so and so, this court observed that if delay has resulted in material evidence relevant to adjudication being lost or rendered unavailable would be fatal. Now I am reading this as this one. My file, original file, we are unable to for this moment, trace the receipts for having deposited the amount in the city civil court.
Yes.
This, my lord, may kindly be looked at it from the context of how long can a government office be expected to maintain the records in its entirety. It is quite natural, my lords, that sometimes certain documents might go amiss, or could also be, my lords, a case where the practice of maintaining the file at that point of time may not have mandated the maintaining of this particular record. So to keep that also, my lords. In light of that, my lords, after 60 years, if I am asked to produce a receipt for having deposited the amount, my lords, if I am unable to find that record, then, my lords, the overall circumstances
Yes.
surrounding the case may kindly be considered.
Yes.
Even though I for some reason, my lords, very strange, I find the reference in my RTI response, but I am unable to find the receipt in the file, my lords. My client, the state of there's another issue. This judgment, my lords, just the other day it came. Just put the delay and latches with respect to acquisition itself. Matter pertain to HMT lands, my lord.
Hmm.
HMT lands also, my lords, were acquired way back in the 1950s
Hmm.
for the establishment of a runway and some other defense established. I'm sorry, my lord, for the Hindustan Machine Tools. This in Jarakbande Kawal. No, my lords, after a very long time, the landowners came before the High Court. Honorable High Court, my lords, accepted the contention of the landowners and set aside the acquisition, which was in challenge before the Honorable Supreme Court. Now, my lord, Honorable Supreme Court decides to set aside the judgment of this Honorable Court on the ground of delay and latches. Lordship may kindly come to para 15, my lords.
Yes.
It is in this context that this court in so and so observed that an aggrieved person should approach the High Court diligently. Delay in filing a writ petition can result in prejudice as parties' position and status may change. Courts do, in cases of such delay, insist that the party concerned should have a good and satisfactory explanation for it. It is only on being satisfied that other factors would not outweigh a grant of relief can the weighty objections of delay and latches be rejected. In other words, a constitutional court should be convinced that the case warrants excessive jurisdiction under Article 226 of the Constitution. In so and so, a 3-judge bench of this court had observed that the grant of relief by a constitutional court under Article 226 of the Constitution without considering blameworthy conduct, such as delay and latches, would be unsustainable even if such relief was granted for the alleged deprivation of a legal right. Discretionary relief in such circumstances can only be obtained upon fully satisfying the court that the delay was justified and explainable. My lords, even the delay and latches even outdoes a legal right.
Yes.
Though the respondent writ petitioners would now seek to place reliance on some internal correspondence, so on and so forth, we are of the opinion that these documents not merit consideration. May I request Lordship come to para 17 minutes.
Yes.
There are some comments made with respect to the facts of the case, my lord, and then the order appeals accordingly allowed. Consequences, writ petition number so and so filed by respondent writ petitioners shall stand dismissed in its entirety.
Yes.
So my respect for, I'll sum up my argument, my lords. 1967, I have taken position. I have formed the layout. 1985, I allotted to first allotment. 1987, they claim that there's a decree in their favor. That's a suit for partition, a collusive suit. Few months, suit gets decreed. It's amongst them. They don't make me a party. Then 2009, I cancelled the allotment. 2010, I intend to allot it to somebody else. Again, there is a public interest litigation. Kindly see the time, the coincidences. That is the reason I say that they're very busy challenging the BDA's or the allottee's ability to enjoy the property. And 2009, I again I allotted to somebody else. Another PIL is filed. I cancelled the allotment. They again seek reconveyance of the land. That reconveyance, since they seek reconveyance of the land, acquisition no longer can be challenged. Reconveyance is rejected. In process of reconveyance rejection, this honorable court has come to a conclusion that acquisition is complete and they are not entitled to challenge the acquisition on the grounds of delay. That order is not a challenge. Now 2016 petition, completely ignoring all that, refusing to in any way have that matter challenged in a manner known to law, they come before the honor. In the learned single judge, some latches on our part in the sense that we ought to place before the learned single judge that particular judgment of this honorable court. We have not done that. I apologize, my lords. Possibly it was not available in the file. So therefore, the matter has attained a finality by virtue of the other judgment. Therefore, the writ petition order may be set aside.
Can we continue with the reply after lunch?
Please, please, my lord. Kindly, there is matter, my lord. One matter, my lord. Fine hearing, my lord, serial number 44. I appear for appellant, my lord. Without accommodation may kindly be granted. In fact, I had informed the other side also. They said they would be here by 1:30. They said they would be here by 1:30.
It is this.
I appear for another respondent.
44.
Several cases. What is this about?
Lord, this is about regularization of the The guest faculties, my lord, who are working in the university.
Hmm.
My lord,
There are
they-
several council.
Yes, my lord, there are several councils are there. My lord, matter needs to be heard and disposed of. My lord, a date may kindly be fixed, my lord, so that on
A
that day. my
short
lord,
date
we
may
can-
be given.
There is the date fixed.
I know, but
No,
La-
if you
I
are
appear for
returning
one
it,
of the
you must-
respondents.
Any short date. may be
Turning
given.
it, you must inform the other council as well.
Lord,
There are several council involved.
no, my lord, but all I cannot inform, my lord. The main person, my lord, one Vinayaka Bhatt, my lord, who appears in most of the cases, my lord, I had informed him. Date may kindly be given, my lord, so that I
I'm
can.
appearing for, on behalf of Vinayak, but
Vinayak Bhatt,
any short date may be given, my lords. The urgency is, my lords, university has been directed to frame a scheme to regularize within 6 months, my lords, from the date of the order, my lords, which has not been done.
We
my
have
lords.
no difficulty. We can hear it on any date, but one of the respondents says, you are the, you are
The
for the.
respondent,
appellant.
respondent.
Respondent, my lord. Respondent number 1 to 22, my
Who do you appear for?
I am appellant, my lord.
You are
Appellant.
the appellant. You are
Yes,
the
ma'am.
university.
I am the appellant. University is the appellant in all the cases.
Any
Date, my lord, can, any date, my lord,
any short date.
next week or whatever.
24th, we can list it. Will you be ready on 24th?
Next week, my lord, date.
Please, my lord.
Dates are
Week,
already.
my lord, because-
24th.
Eight,
Yes, my lord. On that time, my lord, we will go on the matter.
8/11, please
Yes,
make
my
an effort to inform the others also.
yes, my lord. Lord, the interim order may kindly be extended, my lord. There is an interim order. In all the cases.
Tribunal
Interim.
shall remain in force till the next date of hearing.
My lord.
Number
Yes, please be
45.
ready on the,
Yes, my lord.
Date.
Please. 8/11.
Number 45 minutes. And for applying this case, I'll take up next week, minutes in out of station.
who appears against you,
And for applying
who appears against you,
in university, AICT,
yeah, served.
next week, any date.
Served, the notice is served on the respondent,
Sorry, madam.
unrepresented,
Sorry, madam. I'm sorry.
served and unrepresented.
Next week.
At the request of this learned council.
Serial number 41, madam, though the matter is discussed for filing.
Much of them.
The other cases, for respondent number 3 and 4.
Again, four not served,
41.5.
only one case. There are, what about the other matters?
Serial number 41.234, we are for the petitioner, madam. 2 weeks' time may be granted to.
Yes.
Serial number 49, I prayed for time in this matter. Maybe taken up 20th November afterwards. 49.
Have you informed the other side? Please inform the
yes,
other side and
yes,
then
sir.
next. Please don't adjourn without informing the other side. We don't know whether there is any urgency. Yes,
Your lordship, serial number 41, I think it has been,
serial number 41, who do you appear for?
I
Who do
appear
you-
for the, in 5603, your lordships. And it appears that the Supreme Court has already taken a decision on this. Matter has been disposed in favor of the teachers.
We list this after 2 weeks. In the meanwhile, please get the judgment.
Right.
Yes. Where is button? Thirteen. Which is the 230 method? Oh, okay. Shall we just finish this and go back to?
See number 14.
Shall we continue? We'll continue with the.
See number 14, B Vachan.
Or shall we?
Yes.
Yes.
Make it very specific for all. The claim is confined to only total extent which was acquired from Mr. was for 4 acres 30 units.
Correct.
In that one, 3 acres 10 units are the number 32 bar one.
Hmm.
1 acre and 10 units are in 32 bar 2.
Therefore, 32/1, you don't have any contention at all. In this,
Sold previous.
therefore, you are not raising any contention in this writ petition with regard to that.
Small acre, 16,000 square feet.
16,000 square feet in
32 bar 2, that is my contention. But it is combined one actually, you know, my land only taken, was only taken.
Hmm.
It's combined.
Hmm.
Not concluded proceedings
Hmm.
in the year 1954 itself.
Hmm.
Not the acquisition notification of 27 January.
Hmm.
Not the final notification 1964.
Hmm.
No, there was a resolution by the court, CAT,
Hmm.
by when the VD Act was not there.
Hmm.
The video was not there.
Hmm.
CAT was city included more.
Hmm.
Which had acquired the land.
Hmm.
Proceedings and manner of taking all aspects are different.
Hmm.
There was a resolution on 87/1962. So my lord.
Resolution on?
On 87/1962.
Hmm.
What it is, page number 489, I come to that.
Hmm.
Thereafter, my lord, all these landowners, including the petitioner,
Hmm.
or the etc., had challenged the notification.
Hmm.
But this writ petition was specifically, my lord, it was connected 39 to 64, 39 to 64. These are the writ petition, many petition. And my petition of 399 of 64. So connected. There was an undertaking by my lord CATV before the court in the proceeding, saying that, my lord, the resolution of legal aid will be not implemented. There is no that undertaking before the court. But we, all of us have withdrawn it and withdrawn it. But kindly look at one so that memo is already referred to by the director. That's very relevant for the purpose. At page number 469, it is volume 2.
Hmm.
They have clearly stated that for one.
Hmm.
There was a resolution, there was a resolution 29, there was a memo 6, undertaking to implementing resolution.
What was the resolution?
Resolution is number 489. Or can you look at 489?
Hmm.
469, let us see.
Hmm.
469.
Hmm. Hmm.
There's a memo file.
Yes.
All of us.
Yes.
You have undertaken your second respondent city improvement board in the memo dated 27/6/1966. They have undertaken, but the date is mentioned, 27/6/1966. They have said, had said that they will implement the resolution. My name is 470.
What is the resolution?
489.
What is the resolution? 489. Yes, what is the resolution?
Resolution of the candidates.
Yes.
In that, kindly see. Private layouts in a resolution number 7, 8, 9, 11, 22, 23, 24, 27, 30. Etc. Louisville village, from Louisville village, 5 village. Not very important substituted there. All the properties surrounding Wayland are mentioned, etc. Etc. also mentioned. But these properties, several numbers are surrounding my land. All the lands which are taken in the Louisville village have been stated to be relinquished, not agreed to be relinquished. But there says, etc. For this resolution, they came before the court and
Yes.
said, they will implement.
That the proposal to reconvey the lands in survey number so and so,
Yes.
subject to the above condition 1 to 5, only on completion of the layout in the above areas to be approved. Further, the width of roads to be kept as per sanction plan. Lung space should not be reduced. Displaced person consequent of their being reserved for providing civic amenities might, as far as possible, be accommodated in the neighboring areas without any extra cost. The conditions are this: lands have to be handed over to the City Improvement Trust Board immediately. Private layout will have to fit in the City Improvement Trust Board plan. Layout charges will be actual cost plus 10% surcharge. Question of supply of water is not guaranteed. Area shown as parks, playground, CA in the City Improvement Trust Board plan will not be reconveyed. These are the conditions on which the,
The land is surrounded.
Hmm.
7, 8, 9, 11, 22, 24, 23, 41, etc. Of our Louisville village, subject to above condition, only on completion of the layout in the whole area be approved. But the right of the roads kept as so this is the resolution. But what I was objecting about this undertaking of the authority to withdraw to implement the resolution has prompted the petitioner to withdraw the final notification. But otherwise, when challenge would have been there, that's why when removal of 469, it's very clear. My number also mentioned about it, page number 470. But in page number 470, it comes to number 399 of 65. That is B later crop. It's also included.
yes.
That's why my challenge to the British notes ended there because of the undertaking. Lord, etc. lands that included, etc. include might have been even my land also. Otherwise, there is no question of man withdrawing merit petition by the. So much submission is that I'm trying to say that there was a concluded proceeding you have undertaken given by the authority, acquiring authority, or they will implement the resolution. That is why I have withdrawn the petition. But daily come to the Lord, there was it's the intra-court, in the intra-court. They have not produced any documents today, unless you will get. Now they have produced many documents here. Lord, that's why unless you will ask the authority to file affidavits. Specifically point about this. One of them says, what page number 484.
Yes.
There are two of them, one Lease, there is 11 or couple of. But 484, the commissioner filed the affidavit. This is on 211-19. Where is the pendant before the paragraph 3. A subject of the record is all found that resolution came to pass. CCTV, CCAD on 1872, stated that this is what then paragraph 5. Safety, local village all resolution. Paragraph 6, they say my lord, my land is not included. Then my lord, paragraph 7. I further subject two separate severance already passed in regard to both severance question on 18/8/67 by the original president for giving particular merit land for the mentioned there are requesting reconvention of their side and few of them have claimed compensation. Then my lord, further list of various persons mentioned to whom the notice and giving names to various people, including names to different law. This is the update by the Lord Commissioner. Paragraph 8, Mahajan. That is the Mahajan law. Then my lord, I come to the other update, my lord, that is in my lord page number 479. This is the land acquisition officer, my lord.
Just a moment, please.
479.
Just a moment.
Please. There is a class that is 479. But the land acquisition officer has filed a this is Lord on 20/12/2019. Paragraph 2. I submit specify date the value had made list of 61 persons having access for composition and has been sent to Supreme Court that value is state. That is central election after for that there were about 61 claimants and deposit has not been made in the name of Latches Venkatraman as noted in office. Notice sheet dated 8/5/11. The file maintained in the office of LOA option BDA. Deposit regarding deposit award about. It is also noted that 18/11 there is a claim of releasing the land. As per the second portion of the order passed to another court, you have the legal opinion then paragraph 3. I submit there is no reference to any payment or composition or acquisition of land in Survey number 32/2, but this is important. As per the certificate of position of the details of land acquired in only regard to land bearing 32/1, 32/1, not land not showing present of 3 good are being taken as position for the value of the only 3 good are is 32/1. So far 32/2 is concerned, no mention. Therefore, the area shown the schedule claimed to be the continuous position of for more than 50 years as per record coming part of the area. Moving potential has not been demarcated appropriately at the time of acquisition. At the time of taking possession, no proper records are found regard to said claim. Though the land proposed to acquire was 3 acres in Gunda in dry and Survey number 32/1 and 1 acre 20 Gunda in 32/2. And there is no declaration position taken regard to Survey 32/2 and conversion has been taken regard to 32/2. Regarding 32/2, my lord, your learnership friend has pointed out only about 32/1, not about 32/2. I come to that. 32/2, my lord, there is no possession or other asset. This is very clear from their own website. Then, my lord, it is submitted as per the office of voting. Number 30, the record before the land acquisition officer in regard to the land there is Survey number 32/1 and 32/2. It is found that an application.
Yes.
Then, my lord, I read paragraph 4. Submit as per the office voting number 30, record before the land acquisition officer regard to Survey 32/2. It is found that an application made the legal record of seeking release of land. Measuring 150 feet, 140 feet, as they are in position for more than 40 years. But VDA demolished their structure, corrected as their area on 13/7/2011. Thereafter on 3/5/11, also an attempt was made inspection of the voted circular number 2/26 to show that they had rebuilt the compound, continued the occupation. But after 40-50 years, my constructions were demolition, not to be demolition. They made an attempt in the on 3 level, 30 level to the level. Thereafter, my lord, we rebuilt it. That is admitted fact. But this other clearly disclosed apart from the legality of taking possession, my lord, passing of the award, my lord, we got to 32/1. But 32/2 is concerned, there is absolutely no record to show that, my lord, possession was taken, award was passed.
What do you say about this,
But now, London,
just a moment. What do you say about these leases which have been executed by the VDA with regard to this very same property? In the year when was the lease deed executed?
1985.
1985 onwards.
yes, all this.
Sorry, my lord, 1980, my lord.
1980.
They say, my lord, depends on the conduct of video. They say it is civic amenity site.
Correct.
There is no civic amenity site. Admittedly, my lord, Madam Speaker has recorded finding. Layout was not at all formed.
No, as a matter of fact, your property
Yes.
was leased out to somebody else.
Yes,
Apparently, you are aware that it has been
these
leased.
are not paper only.
However,
Yes.
no challenge.
So, my lord,
No challenge to the leasing out of your property, which according to you, you are in possession.
so before the court, there was challenge, one of the things are filed public investigation, other one also filed.
Public interest litigation cannot be your challenge.
One is public investigation.
Yes.
That's subsequently PSA.
Which is your challenge.
PSA is concerned.
Hmm.
Not regarding the debt, the debt is got that, and explain that.
Hmm.
Lord, hey. PSA will not, though will not, possession, whether possession was taken or not. You will not there, depending upon two documents, but page number 387 and 521. But here, this is the stated to be the Mahadev law on 17/6/97. But the English translation is found in page of 387. But kindly see, this is only pertaining to 32/1.
Why do you say so?
Kindly see, as per the government order dated for the amounts of lands acquired for the purpose of the side of major land reading 32/1 had already been acquired. Award also sanctioned. This award notice from the above office LAC for the seventh cost for landholder. And it was stated that on 46 that possession had been taken, you are required of the revenue inspector along with the staff acquired none of the landholders of brother.
Acquired the land of survey number 332/2.
I come to that. According to 61 notification, the revenue inspector had acquired the table land in our brother and handle the bills of the charge of labor and there are as per the measurement of land, the revenue had stored approval of the land. As per their the area of this land is 3 guntahs of Tarap and dry land measuring 3.10 guntahs is there. This is about 32/1. Or 3.10 guntahs is 32/1, not 32/2. So other one is not 521. Brother Mahadev is not 521. 11 portion is 522. This is done on 46 times. Paragraph 2. As per the government also, current book 32/1 of Procedural has been acquired out of the land acquired for served as presented. Award was given. On this date, revenue inspector and other staff are come to the office. Landowners. In fact, this is wrongly translated. No landowner has come over to hand over the land. That is the real one. accusation could have taken person with that land as per section 15 of the Transaction Act and following the order text. But maybe only 3 acres 10 quintals of land. In 32 bar 1 is mentioned. I look at the next page, 523. Taken possession of 3 acres 10 quintals of land surrounding 32 bar 1 of the layout. Even this one, I'm not saying that what is it in order to admitted that other land possession has been taken. That's not our case. We have not admitted that the possession was taken. So when you look at the apart from that, when you look at the Mahajan, when you look at the Mahajan, only the signatures of some panchas are shown.
Now, what is the reason for your approaching this court in 2016 with regard to
Because
something which they say has happened in 1967?
Because my lord, all along my the learned citizens pointed out, my lord, my application for reconsideration my father was pending. That was not considered. And I have also filed a application for reconsideration. In the year 2011, or 2011, my lord, they have come with officials that demolish the portion of the building. Immediately.
Then what happened for 5 years? After 2011, what happened for 5 years?
Then in 2011, my lord, they have demolished it, my lord, we rebuilt it. We rebuilt the building. That is what coming out in their very same, my lord, affidavit. Thereafter, we have not continued to be in possession of the property. And my lord, we are pursuing our reconsideration application and other aspects. Then, my lord, they are continuously interfering with our position. They are not allowing to enjoy our property. My lord, we have showed the Authorized certificate, my lord, payment of property tax, and the building show all photographs connected here. All of these documents are there and record. My lord, when they continuously interfering up to the level after attempted demolition, my lord, we have a position on court seeking, my lord, a relief, a declaration form that, my lord, the acquisition has been already abandoned.
Yes.
My lord, when you look at whether possession was really taken.
If it is your contention that you were always in possession,
Yes.
there is the question of reconveyance at all.
Reconveyance in the sense of possession is one aspect. Possession is taken. Possession is not taken. But land was yet to be acquired. They have not found the layout, admitted. But what happened is, they have not found the layout at all. But leaving alone other aspects. 32 bar 1 and 32 bar 2. Totally 4 acres 30 quintals. They have not taken possession of any one of these lands. Admittedly and after they stated that reconveyance has been done. So far as my land is concerned, my lord, they are not considered it. Though I have withdrawn my restriction, challenge the handling of the 64 itself. They have not done that. My lord, after several years in the 2011, my lord, they have started demolition of construction.
Therefore, if you withdrew your petition on the condition that they would reconvey, and they did not reconvey, then what was the option available to you at that stage? Should you not have approached the court then? Is it open to you to say that because they said they would reconvey, they did not reconvey, so I sat on it, and after 20 years, I suddenly, or 20 or 30 years, I realized that they did not reconvey. Therefore, and they came and disturbed my possession, therefore I am here. Is it possible for you to say that? What is the reason that you have stated for the delay in filing the petition?
Delay cannot reckon against anyone because it is a case not where trying to interfere with the possession in the year 2011. 2011, not they interfered. Not they have not taken any. Not they have not found the layout at all. The last have gone through the application criteria.
Then at least from 2011, please explain what is the reason for
Thereafter,
approaching only in 2016.
Thereafter, my lord, I have filed one of the entries before the court.
And what happened? What happened?
16 mandamus, my lord, that mandamus was not allowed.
Yes.
Thereafter, my lord, they against to my lord interfere with their position. More than, my lord, I filed this petition here, 2016.
Yes, your 2011 writ petitions were what led to writ appeal number 2633 of 2012. Correct? Absolutely. 45314 of 2011 and 46661 of 2670 of 2011. Judgment dated 28/2/2012, from which this appeal happened. Yes.
Lord, can you look at the possession Mahazar? Lord,
Yes.
admittedly, there is a building.
Hmm.
It is not a legal plan.
Yes.
Lord, can you look at the Mahazar page number 521?
Hmm.
No notice was issued to the landowner. Lord, their signature is not obtained.
Hmm.
And Lord, the even regarding Mahazar's witnesses to Mahazar, their identity is not disclosed. It is totally in the cyclostyle form. Lord, there is a judgment of this on court.
Are we considering the 1967 Mahazar today?
Lord, possession is with me now.
Yes.
But what I am trying to say, Lord, because he is asking for in those judgment, whether it's applicable to this case. But what happened here, there is no Mahazar in the manner known to law. But in the Bandha Development Authority case, this specifically held that court, when the building is existed or there is a crop, the landowner should be notified and their signature has to be obtained. For which court, this Mahazar is not as produced for their court.
Yes.
Lord, so Lord, there is no clue from whom the possession was taken. In the entire Mahazar, it doesn't reveal from whom the possession was taken.
Yes.
But more importantly, my lord, it was only regarding 32(1). That according to what your a notification under 16 subclause 2, section 16 subclause 2, intelligent notification for having taken possession should have been published. Even that is not been done.
Yes.
My response of this is that, my lord, possession of the land was not taken. They say, my lord, they have taken the possession. They have not taken the possession of the land in the manner known to law.
Yes.
They were coming to give an awards.
Yes.
They have referred to 2 documents. They are under the same. And look
Yes.
at the awards they have passed. Page number 491.
Yes. Yes.
So this is also only, my lord, regarding 32(1). And you see, well, at the beginning itself is stated, Sanam 32(1).
Yes.
And ultimately, your last one can you see at page number 500. Award was sent to have been passed only in respect of 32(1), measuring 3 acres and 7 gunters. See, well, kindly see, well, all along it's separate only 2, 3 acres, 7 gunters of land 32(1). Last kindly see, well, page 49, 499. Second paragraph. As land has already been notified for acquisition, urgently promotional labor can also, not 3 acres, 7 gunters of land in the turnover 34 village. There was a part of people here.
Yes.
There is no mentioning about 32 where this particular piece of land is situated. But as per submission, my lord, apart from the legality of my lord, the manner in which they have taken possession, my lord. Even otherwise, possession was allegedly taken only in respect of 32/1, whether the my lord 3 acres and 10 hectares.
Yes. Thank you. Survey number 32/1 is clubbed together and sites formed have been sold to several persons. Therefore, it is not possible to say what extent one has purchased it. 32/1 and 32/2. Moreover, nobody has produced documents to show that he is absolutely. But the. His NPL was page 500. Yes.
One hand or three feet affidavit only, their own officer, land acquisition officer says that only 3 gunters of land, possession of secretary that. And my lord, the document produced here shows that they have taken possession, if at all, my lord, 32/1. But they have not produced any document before the order from the London signature, showing that possession in regard to 32/2 is taken in accordance with law. And my lord, there were this small piece of land, after 4 acres, 30 children have lost, my lord. Only small piece of land is going to be legal as of the regret of. client, my lord, they don't take possession at all. They have to put in the document so that, my lord, possession was taken in accordance with law. But we are looking at the legality of the Maharajah, my lord, look at the man which Maharajah is gone, my lord. Landlord's signature is not there and it was not notified.
What do you-
But vacate, my lord.
What do you say about the earlier round of litigation with regard to the very same property?
Yes, no. Very same property. my
One
lord,
15 feet into 140 feet.
Okay.
First cross, second block, Banshandri first stage.
So, can you look at the latest, my lord, can you look at the latest, my lord, allotment allegedly made? For the connected petition, now, my lord, the land is allegedly allotted to, my lord, ADM. Can you look at, my lord, the connected petition, my lord, page number 198.
Yes.
They have allotted on 7/4/2012. But this is only allotment data. There was no acquisition of lease. First of all, it got a civic community side for civic community side, one last time kindly look at the definition, who gave the rules, very clear. We know, civic community side means very, they are not for civic community, they were found by the authority. But here, admittedly, layout was not formed at all. But there was no layout forming. Their own officials say that they are not formed layout. And what they also say that there is no allotment to any of the beneficiaries.
Yes.
Without which, my lord, that there is no question about civic amenity. That account, when you look at the latest allotment on 7/4/12, it is only an allotment, which is not further, my lord, proceeded in the executed lease deed, registered lease deed.
Yes.
Or this is only allotment letter. Or it is conditional. The allotment letter is conditional. One of the conditions, my lord, they have to execute the lease deed, they have to pay the payment. Or that is condition number 7. ಗುತ್ತಿಗೆದ ನಿಯಮ 10 ಅಂದರೆ ನಾಗರಿಕ ಸೌಲಭ್ಯ ಮತ್ತು ಯಾರಿಗೂ ಪರಭಾರ ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಆಮೇಲೆ they have to register it.
Yes.
When you look at the rules, that is 10 subclause rules, 10 of the allotment rules of PDA. Clearly says that a lease deed or any allotment will be final only of the execution of an agreement. And there is a execution of a registered lease deed. Let them show any deed where they have registered the lease in favor of DBA. Thereafter, they are not supposed to subdivide it, sublet it. Thereafter, they sublet it. Then you look at next page 230. This is to a much on the resolution passed out 2018. But first of all, there is not completed allotment at all. Only letter was issued. Secondly, my lord, they have subletted in violation of the grant condition. So, my lord, there is no allotment at all as of today.
Allotment is quite another question. We are not considering the issue of allotment. That is not the challenge at all. Challenge is with regard to.
Challenge in the connected petition, my lord. That's a BBMP before the lordship. BBMP before the lordship saying that land has been allotted to them.
Correct, but you did not challenge the allotment. We are not considering the allotment. They only say that it has been allotted. Whether it is allotted or not is not the question we are considering. Yes.
On it of BDA, can you take Tata at page 109?
Yes.
Right, Tata at page 109.
Yes.
The Tata certificate. Again, with this small piece of land.
Yes.
Then we want all these property tax paid receipts, page number 112 onward. Up to the date of filing in petition, in the 60.
Yes.
There were building, my lord, they start to demolish. Can you see the building now?
Yes.
Photograph is produced. Kept to video 105. Then my lord, case 109, 109, Tata. Fill in the name of the petitioner.
Yes.
Then my lord, all these receipts for having paid property tax. Annexure J, J 112, up to my lord. Annexure N 160, Annexure R 190. They have collected property tax.
If that be so, 32/1 also you are paying property tax. It's not only for 32/2. For 32/1 also you are paying property tax.
I am paying tax only for this small piece of land.
It is not so.
The building tax.
That
It is
is
not
there
so.
particular about that.
You are paying building tax of 30,920 in respect of 32/1 and 32/2. By check. Venkatrao still paying for the entire extent. Apparently. Where is the Khata certificate?
109, 109.
Hmm.
Khata of property number, gold surrender number, 32/1
32/1 and 32/2. Shankari first stage, second block, first cross. Khatas in respect of the entire property.
They are issued it, Khata is standing in my name. To
Yes.
show that I am in possession of the property.
Yes.
Lord. So
Yes.
the latest allotment is also in favor of Lord BBMP, is not veterinized in the form of a registered lease deed.
Yes.
So when you look at the conduct of BDM,
Yes.
they are not from the layout at all, admitted.
Yes.
And Lord, there is no allotment to anyone. And Lord, others lands in my village, Dovipuram, has been excluded. All lands have been excluded. There is no dispute about it, Lord. This is an island there. They have excluded every other item of land in Dovipuram village. There are not, even they get 32/1, 32/2, my Lord. Possession was not taken.
Yes.
Entire 4 acre 32 of land, they have not taken possession at all.
Yes.
Then, my Lord, earlier they have given undertaking to before the court. Have already completed it. Now, when you look at the judgment, one of the judgments about that. Judgment. Question is that, my Lord, delay cannot be held against me, my Lord, because they are the one who are interpreted their position in the year 2011. Till then, my Lord, they have not interfered at all. So delay is on their part.
Yes.
Relying upon the judgment of Supreme Court in Kodu Ramaswamy's case. Case number 99.
Yes.
Paragraph 160, conclusion part.
Hmm.
Roman 2 there. With regard to the villages of Venkatapura and where there are several small pockets.
Just a moment, the
Page
paragraph number,
171.
171 of the judgment. Internal page 171 of the judgment. Paragraph,
60, paragraph 2. Regard to the villages of Venkatapura also, where there are several very small pockets of acquired land surrounded by land which were not acquired or which were deleted. So deleted from proposed acquisition, BDA may consider whether such small pockets should be also be deleted if they are not suitable for farming self-contained level. The acquisition thereof cannot be justified on the ground that these small islands of acquired land could be used as a stand-alone part or payroll with regard to layout form in different unconnected lands with other villages. Similar isolated pockets in their villages also be treated in similar manner. So also another paragraph. And page number paragraph about the paragraph 4. All in a village, all the lands are notified and subsequently all the lands except for 3 small pockets are deleted. Without any valid ground. The person whose lands are acquired can also take deletion on the ground that all the surrounding lands have been deleted. The court cannot direct deletion there because surrounding lands will be as the deletion committee cannot make a report. But the petitioner can contend that very person continuing has been rendered infructuous by deletion of majority of land from the proposed acquisition and the project or scheme that may cease to exist and cannot be executed only with reference to their land. In such cases, it can be granted not on ground that situation, but also for that proposed development scheme is non-existent in the form of both land. What I'm trying to say about
yes. Yes.
the very same word operation or the agency, the first judgment. Third judgment will be 37. Paragraph 37. This is referred by the page number 54. Paragraph 2. There is a building or mere spot inspection or appreciate or the landowner's situation has to do it and what that should be noticed.
Yes.
In this case, the landowner for lordship seeking relief that for a small piece of land is left with them. It is their Lord property like the constitutional right. So they are seeking a relief with the said Lord, they are not followed any of the process. There is no layout formation, there is no allotment at all. They have not produced any document to show that position was taken. But let them produce document so that position was taken.
Yes.
They have not produced any document so that position was taken in regard to part 2.
Yes.
There cannot be a blanket walk over to the BDA. Saying that there is statutory authority, they can act according to their written as is.
Yes.
Even today, my lord, I am in possession of the property.
Yes. Yes, what do you say, PBMP?
But regarding indoor development or okay, so indoor development case is not applicable to this case because what it is pertaining to section group 42 regarding due to lapse of custody. But condition is that what is the recent past before the passing of the act.
Yes.
5 years award was passed. And Lord, the possession is not taken, and Lord, the award was not tendered, but it is within lapse. But here, my lord, the indoor judgment was only referring about pending proceeding. It's not a pending proceeding, my lord.
Yes.
Indoor was specifically about pending proceeding. They require last one paragraph in the indoor judgment.
Yes. Yes.
What are our moves, section 24, possession and transportation, and we deal and take under section 24. The experience where the inaction of the authority for 5 years or more prior to the commencement of the act, the possession of land has not been taken, nor compensation has been paid. In other words, the case, in case possession has been taken, not it is about.
That was not what was argued at all. It was only the discussion as to how possession is to be taken under the 1854 Act. Only those two paragraphs that were relied on, not for the purpose of the proposition laid down.
366 says, provisions of section 24 to providing for deep lapse of proceedings are applicable in case authorities have failed to due to their inaction to take possession and take ownership 5 years or more before the 2013 Act they will enforce. The proceeding for retribution pending with the authorities concerned on 1/1/2014. That's why he's citing the judgment. That's not applicable to the same law.
Citing the judgment only with regard to the discussion in the judgment with regard to possession under the 1894 Act, nothing else. Yes. 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 Yes.
Paragraph 6. Paragraph 4.
Shall we just go to the findings?
I think all along, not everywhere it is stated. They permit to bring because
We've read the judgment.
that's why, however, what is notable is not there was it.
Absolutely.
They say what.
Yes, we've read the judgment. It says there is no material available with the BDA to show that provisions governing the making of the award, tendering the amount have been complied with. Most importantly, what is noticeable that even under the award, there is a statement that the award amount shall be deposited before civil court. No material placed on record to show that the award amount was really deposited. We understand. Yes. Yes, that is why the judgment has come about. Yes, please.
Submit that as is evident from the award and the discussion made therein, which are related to the observation filed with the land use officer as well the commissioner. All the lands in Northern village which are initially notified for acquisition have been dropped from acquisition for the lease. But this is from the update. Except 32/1, 32/2, the application of the land use of the BDA is that after mentioning the Tribunal so it is followed by the word etc. That is the reconveyance resolution.
Just a moment, sir. Yes.
Word etc. Said word should not be disclosed to include the practical bar. And there is no specific mention of practical bar one and practical bar. It cannot be taken as a word including practical bar one and practical bar two. Moreover, it is submitted that once it has been voted into a lot, companies have been defined and same was directed to the government. There should not be any other so that the land is not. 24. What remains with the picture is only a small piece of property measuring 150 to 140 feet. 24. It is relevant to notice that all the lands in Proceedings except around 31, 1 and 31 have been left out of the execution proceedings. A categorical finding.
Yes.
It is hard dividing how VDR more than 60 years from the date of criminal notice is taking claim with respect to a piece of property measuring about 150, 140 feet. When admitted, nothing has been done with respect to so-called 4 acres of 30 acres of land, those which it is stated that award has been drawn and complaint has been deposited in Procedural. Admittedly, no layout has been formed, even in that 4 acres of 30 acres of land is available. No material is created for the court so that the action of the authority has initiated against the entire extent of 4 acres of land. The contention is only on this piece of land measuring 150 to 140 feet. No material space for the court to or record show that the structural notice under section 16(2), that is the budget notification, was issued before taking possession of the land. The Mahajar does not bear the signature of land owners. More importantly, it is an admitted question that several owners seeking claim that they had purchased with a piece of property in the nature of residential sites, out of the bar 1 and 2 nature of residential sites, out of the and made application seeking recurrence of the piece of property. But then on page number 34, that's page number. I'm going to read that very same paragraph. So the last 5 lines, therefore, it at any rate cannot be held that the respondent VD has taken possession of the land in accordance with law. The position continues since it is admitted by the respondent VD that they have not found any layout in practical bar 1, practical bar 2, related.
Yes.
But then the paragraph 35 a lot of the citizens refer to the control numbers of the state capital.
Yes.
Then more any come to page number paragraph 38.
Yes.
28, paragraph 28. Admittedly, there is no material with the media to show that provision governing making of law award, taking of the award and tendering the amount to the land to the comply with. Most importantly, it was even under the award, there is a statement made with special and that the award amount shall be able to report. But there is no material before the court, so that the award amount was really deposited to the court. If the landowners are not notified regarding deposit amount, nor they were part of the current company they were not. But 12 to notice was not issued. But all along this award, section 10 notice, section 11 notice issued. But there is no notice under the section 12(2) and 31(1). Either would tender in the award or not, even after the passing of the award.
Yes.
Then will not.
filling of the judgment of this on court order. 3 lines. The Mahajar is in a psycho-style form, just contains signature by person. Neither their names nor their addresses are shown in the Mahajar. It is next impossible. Presently, the identity of the Mahajar witnesses. It is possible. Property to report the position in the case of United Maya and others also. Regarding Mahajar.
Yes.
Then 31. For referring to Pralad Singh case or it was held that vesting of the land under the signature of land is supposed to accumulate until it is done. Legal presence of vesting enshrined in section 16 thereof is not. But by submissions, there is no vesting as such. No vesting of the land. Because there was no taking position, nor there is no passing of the award, nor there is tendering of the award compensation. This is what 32. Page number 35, 32, page number 45. We skip over it, like, really focus on number 6, 7, 9. Even in the absence of any of such prescriptions expressly under the statute, having ensured the fact that right to property is a constitutional right, and the person whose land is sought to be acquired is entitled to compensation at the market rate, such a cost has to be paid to him at the earliest. Therefore, the power of this should be set in a reasonable time, so that the person who wants property duly compensated at this point of time. It is with regard to delaying award, acquitted award, not even achieving the award of past. Then 33, not 34. 34, okay. The petitioner continue to be in possession of the land in possession for more than 60 years now. The petitioners continue to pay property tax to the BBMA. All the neighborhood property was sought to be acquired under notification to the extent of 4 and 30 with the 7 of 32 or 1 and 32 or 4 is not in possession of BDA. But that is not in possession of BDA at all. Then various landowners who have made their applications for acquisitions to the land acquisition officer seeking reconnaissance of their pieces property have continued to be in possession of without any length and ignorance of BDA. That being the position, the respondent BDA has failed to prove that they have complied with the statute requirement as provided in the Land Acquisition Act, more specifically section 30, 12, 16, and 31. Or 30, 12 regarding notice afterward, 16 gazette for having taken position, 31 1 tendering amount of compensation.
Yes.
In the result, it declared to be abandoned, response is supplied. No, they are not saying that I will unauthorized occupation. That is the case for only even section 38 D of the Act also will come into that figure. But if I will unauthorized occupation of landowners for my property, that is what more is all others are against property. Those who still from neighbors for not their
Yes.
and therefore, my lord, all these documents they are now producing was not produced to the learners in the day. And my lord, they are quite appealing, saying that they are not from the level. If at all, also this of the opinion that my lord, possession taken according to the law, what is passed, then my lord, this all has to reconsider the learners in the day. Because they are not the document to the court.
Yes.
And delay cannot be taken because we are going to go accommodate demolition here to the land, which founded will not come to the court twice. Of course, the other petition will not refer to the land, where I have sought a random for reconsider. But it was rejected without any explanation or order, detailed order. Learned the division will follow. They not was passed, they that proceedings are concluded. But it's a randomous, not a case where these things have to be gone into. And these aspects of detailed aspect of position, award, and other things for lapsing of things was not the subject of that proposal detail or learning. That was a asked in reference by the Honorable Court. Saying that you cannot keep recommendation now because already it was concluded. But these contentions are not raised. Now these contentions are not present by the court. So
Yes.
that is a different issue altogether. As to any consider the detail of the this region. That's why because cannot not very clear.
Yes. Yes, what do you say, BBMP?
My lordship, the BDA is a claim that is a CA site, my lordship. Regarding CA site, they allotted me in the 13/12/2011, they allotted me to in the purpose of the hospital setting, my lordship, in the 30 years. I paid it 38 lakhs something amount, my lordship. And I am in the BBMP is in position, my lordship. As on still date, there is a kata in respect of social property in the BBMP, my lordship. And we started the estimate to the cost of the put up the hospital, my lordship. So far, at the time of COVID time, we have some delay for the delay that, my lordship. You are not immediately put up the some hospital purpose, my lordship. As on date, and what happened, my lordship, the writ petition, we not they made the party, my lordship. I was not party in the writ petition, my lordship. After we came to know that who has responded, they applied for the kata before the BBMP, my lordship. We rejected the kata. Then we know that the BDA has executed to the elected in favor of the BBMP. BBMP is in position, my lordship. I paid it 38 lakhs amount in the 30 years for the lease period, my lordship. Therefore, my interest is already paid a 38 lakhs amount from the BDA, and also I am also BBMP's position of the still in the, my lordship. Kindly see the page number 205, my lordship. My writ petition, my writ appeal, my lordship.
Exactly. Yes. Then if all this is your contention,
Yes.
why were you accepting the property tax for
No,
issuing
no,
kata
no.
certificate?
What
for
happened, my lord?
the
They,
entire property.
no. Now they have filed the, no.
The property that
My
they are
lordship.
disputing, the entire property kata is still in their name.
We have rejected. Now they have filed the one more writ petition. We have rejected. Therefore, the writ petition number 2095/2023, they filed the kata.
After all this happened.
After the happening, they filed the kata.
Created the entire confusion.
So therefore, now they filed the kata. They're seeking for the kata in favor of the respondent, my lordship. Still is pending from the in the writ petition, my lordship. See, my lordship, 205, it shows that there is a kata in favor of the BBMP. As on date position of the BBMP, 2005, my lordship, the page number 205, kata in respect in the favor of the BBMP, my lordship.
It is the effective date.
That is the date is, my lordship, up to 2011 to till date 1/4/2006, my lordship. 1/4, yes, my lordship.
2016.
16, my lordship. As on date, the BBMP is in kata in favor of the BBMP. And kindly see the page number 216, my lordship. BDA has wrote the letter from the BBMP. My lordship. See, 217, my lordship, page number. With reference to the above caption subject, CS8 number 10, BBMP, situated BBMP ward number 156, Srinagar, Bangalore, has been allotted to the BBMP for general hospital building construction. Allotment letter has been already issued by letter so-and-so number for lease period of 30 years. The allotee has been sought out pay lease amount of 38,52,486 accordingly by paying the 38,52,486 those DD number so-and-so bank and situated BDA premises 19/11/2012 by enclosing the remittance of challan along with letter so-and-so reference. Commissioner BDA has been sought out send the draft lease agreement for registration of lease agreement. Despite sending draft lease agreement format from BDA already, BBMP has not reached lease agreement with respect to the said property so far. In the letter under reference number sent to the format of draft lease agreement to the Commissioner, Bangalore Mahanagara once again request to register the lease agreement. And civic community site number 10 of the authority is already transferred to the BBMP on 7/4/2012. On the basis of allotment letter as informed by you on letter under reference so unauthorized building standing in the said civic community sites were vacated. Since lease amount with respect to the site is already paid to the authority, you may take action to protect the said property under your position. Further, you are once again requested to register the lease agreement as per the format draft lease agreement sent to the Commissioner BBMP via a letter of BDL so and so urgently. Again, my lordship. One more communicate, my lordship, and 223 page number, my lordship. With reference to the above caption subject, since CH-8 number 10 of BDA authorities at Srinagar, BB for number 156, allotted to the BBMP for construction of General Hospital building. Said site has been transferred to BBMP 7/4/2012. Since the said property is presently BBMP in possession, we have to take action, protect the said property. Hence, the Commissioner BDA has to sort out register lease agreement urgently as per the draft lease agreement sent to the BBMP. Hence, you are requested to enter the agreement BDA. Again, one more communication, my lordship. The page number 228, my lordship. The Adi Chinchanaga Mata is very famous, so and so, it is popular, so and so, it is like to the live orthopedics people. Sri Adi Chinchanaga Mata has stated many education institutes in the rural urban region for the benefits of poor and backward children irrespective of cash or credit. In C Adi Mata Institute are more than 1 lakh students are getting education, those more than the 500 institutions. It has come to our notice that CS8 number 10 behind PS College, Bansankiri first stage, second block, Srinagar ward number 156. BBMP has proposed to establish PHC Health Center under the public-private joint venture on contract basis. We have decided to construct well-equipped hospital under joint venture of the Adichinchagiri Mahastamata Mata and BBMP on contract basis render go health service to general public. Hence, we request to kindly accord your consent on this subject. One more communication, Malaysia, page number 232. The resolution passed meeting in BBMP subject so and so number. And on lease basis for period of 30 years in accordance with the rules for construction maintenance of general hospital in the said site VPP model and Srinagar ward number so and so number. CS8 has been allotted to BBMP for BDA for construction of general hospital. The meeting has unanimously decided that commissioners should take action to convince the said CS8 Sri Adichinchagiri Mata Bangalore on lease basis for 30 years according with the rules for construction maintenance for general hospital in the said PPPT model. As on date, my lordship, we were in the being a portion of the social property, my lordship. And we paid the 38 lakhs to BDA, my lordship.
Yes.
But one of the conditions for allotment is that they have taken the lead today, particular day. But they have not done that. Before we told you, they have already separated the land for not a particular very popular and but not as per 230, page 230. But before the execution of the lease deed only, it's already separated. In violation of the conditions of allotment. One of the conditions was they are not supposed to apply. They have to construct it for hospital. Now, without even a lease, registered lease deed, they have already got so they were subject to property. This is the vested interest behind this for petition. Otherwise, what PD was not so powerful or forcefully produce land document for learn a single land. But now, we are coming out after delay, they have filed their deed. Hey, you see what the whether there is a lease agreement, lease deed.
We consider those. Yes. Yes.
How really did, sir?
Clarification.
How
Yes.
really did, sir?
The argument is not to be improvised. There is no distinction between the two ceremonies. Lordships may kindly come to the schedule in the petition. But in page 66, volume 1.
Yes.
Schedule of the properties. All
Yes.
the pieces parcel of survey number 32/1 and survey number 32/2 under presently registered corporation number first class, second class, 130, first stage Bangalore measuring 150 into 140 feet. The challenge is not the 1 survey number.
Yes.
First, improvisation. Now, as with regard to the contention, my lord, I'm not produced any document to show that 32(2) has been, award has either been a past or position has not been taken. They produced it. Lordships may kindly, it's not just I listed it there. Third thing I'd like to say, my lord, that another documents which I refer to, my lord, has been placed before your lordships only by way of an application. All these documents were available before the learned single judge. It is not a case where filed by way of an application sought to put as additional document or just a simplified or other method. Simply interactive senior person is getting that.
Yes.
But in my volume 2, so not my kindly take. I'll point out the 2 awards and the 2 markers. 32(1), your lordships will find it at page 356.
Yes. Yes.
What copy is at 356? That is 32(1).
Yes.
The Mahajar of 32(1) law. Page 3. The translated version of law is at page 387. Second, Mahajar got it in place assembled on the land bearing 32(1).
Yes.
I request my lords for a moment, kindly come to the Kannada version of the document, because the translation is so wanting, so sorry. It was impossible for us to review all the translations. Page 383, my kindly will see the lords. The Mahajar in Kannada. That is the Mahajar in Kannada. It is not in a cyclostyle form. Cyclostyle forms came subsequently. BDM lords came into place 1976. Much later, cyclostyle Mahajars have come. My lord, if I may say this, my lord, my entire Bangalore city where I have formed the layout, I have a similar kind of a Mahajar. Similar kind of a Mahajar. I am not in any way change the Mahajar, cyclostyle form. But anyhow, this is not a cyclostyle Mahajar. Kindly come to the next page. Page 384.
Yes.
What is written by hand? Taken possession of, in English, taken possession of 3 acre 10 guntas of dry land in Channel number 32/1 of Ravipura village from the RI CATV as shown by the revenue surveyor of the board. It is 32/1. 32/2 lodgement will find that the award copy at page 344. Same book.
Yes.
Award is at 344. The Mahajar is at 350.
Yes.
There is a Mahajar, it is not a cyclostyle Mahajar. Lordship may kindly come to page 351, the same lord, same hand. Taken possession of 1 acre 20 meters of dry land in 32/2 Ravipura.
Yes.
But both the cases have passed separate award, has passed Mahajars are there. Lord, that is as far as awarded Mahajar is concerned. Now, the one of the argument, my lord, that was before this, that when affidavit filed by the special land acquisition officer, admitting to certain positions, I'm not in a position to disown the affidavit filed by me. Cannot do it. But if I may kindly request your lordships, kindly consider it in light of section 92 of the Impending. nobody can say contrary to what the records. Records speak for themselves.
Yes.
Any position which my lords, the officer seeks to take whatever advice that is got on the contrary to the document has been known. Kindly come to volume 1, page 106 minutes. It's not a produced by the respondent.
Yes.
The land, the board materials, sonar, their document.
Yes. And then the next photograph also. It appears that the name of the Sangha is painted.
This suit, my lord, is a suit for partition, filed by the respondent among themselves, suit for partition, and which got decreed as expected in a few months ago. I was not a party in that.
Yes.
The argument for the lords that it is not a civil community site, that it could not have been a civil community site. I have to place one judgment placed already before your lordships. I kindly request your lordships to take my judgment compilation. The second judgment.
Yes.
Page 273. 273.
Yes.
Issue of acquisition in here. Can you see the observations made by the that's lords level? In page 280, para 22.
Yes.
In view of the above, the law can be summarized that once the land is acquired, it rests in the state free from all encumbrances. It is not the concern of the landowner how this land is used and whether the land is being used for the purpose for which it was acquired or for any other purpose. It becomes persona non grata. Once the land rests in the state, there is a right to get compensation only from the state. The person interested cannot claim the right of restoration of land. The reason why I am pointing out this out is that the argument that civic community said BDA was not interested, that some highly handed people are trying to push BDA to this deviation. I might tomorrow cancel the civic community state and I might want to do an apartment project there. That does not in any way give them any right to seek question of the acquisition. So therefore, that is not permissible.
Just only incidentally. It has nothing to do with the merits of this case.
Yes,
If as a matter of fact, there is a layout, and if there is a civic amenity site attached to it, or possibly even a park or an open space, can you use it for any other purpose? If the layout contains an open site or a civic amenity site, can the BDA or the BBMP for that matter, or whoever is forming the layout, can you as a matter of fact say that,
Reason, my lord, under the comprehensive development plan, my lord.
I just wanted to know that.
There is a proportion in which I have to do a CA site, a park and open space. I cannot violate them.
Correct.
As a civic community site, my lord, hospital is permissible under the civic community site as per 2B, my lord. There is no violation of the sanction. Why I am saying this, my lord, is that they want to say that I have not formed the site or I have not done anything to that extent. So that's the reason I want to say is that how I use the land, my lord, is not for the landowner. Tomorrow it could have just been a road. It could have been a road or it could be a private site. Or I could have been.
If as a matter of fact, there is a violation or a use of the civic amenity site for some other purpose, possibly anybody residing there can have a cause of action.
Anyone else has a cause. Anyone else has a cause. Here I continue to use it as a civic community. And my lord, that argument was made as an island and that there are no other sites that have been I had cited it in the my first instance when I argued the matter, where my lord, I had shown the boundaries of the CSI, which at page number 197, the boundary in the lease from sale agreement, there are two more civic community sites. Two more civic community sites adjoining this site. One is west by CSI allotted to Swami Vivekananda Vidyashala.
Yes.
North by CSI allotted to PES College. So I do not, my lord, agree with the argument, the learned senior counsel, lord, that this is some isolated pocket of land. In the entire argument of an island argument, my lords, came about before. VDA, my lords, in exercise of which passed in the section 80, or subsequently the state under 48, went about denotifying land or not going into the final notification, forming small pockets of land of 1 acre, 1.5 acre, in a manner where it can't be used in an integrated manner for the purposes of forming the layout. In that context, my lord, it was said by this honorable court in Bundu Ramaswamy's case, that if it's an allegation there, my lord, was the petition, that the malafide exercise of power by the officers concerned, then in a very rampant way for extraneous considerations are denotifying the land. And this issue, my lords, was discussed. Then the learned, then the this honorable court came to a conclusion that if it's an island pocket, you can't develop it. So please don't do it in this way. Here, that is not the case. Here, that is not the case. Here, I have CSA adjoining my this CSA. So it is not an island. So that argument is not the argument. Their entire argument, my lords, was that we have not taken position. Scheme has not been given. That is the argument, not that island. Island argument was not urged before the learned. Even assuming for one, my lord, it's urged also, my boundaries, my lord, the CSIs are there.
Yes.
Section 38D, my lord. Section 38D is concerned. Section 38D, my lord.
Sorry?
He said there is another topic.
The argument was put forth that
they are giving violation of the not going to not PPA. Now there is some not.
Anyway, that is why we said we are not considering the issue of how it is used. We are considering the question with regard to your right over the property. That is, we are confining there. Yes.
The big section 38D, my lord, was referred to. Reconveyance, my lord, has already been rejected by this honorable court. One is that. Second is, as far as the resolution, my lords, of the year 1962, my lords, I pointed out point number 5. That is, the land is used for the formation of CS site or a park. It's not available for reconveyance. And now that the passing reference was made that it has been summarily rejected, for the sake of records, my lord, the order passed to the learned single judge, which was an appeal before this honorable court, where their order was rejected. Learned single judge order was the summarily dismissed was what was submitted to the learned single judge. That's the reason I want to place it. Learned single judge refused to even consider representation. Thank you.
Yes.
Paragraph page number, print page 5, paragraph 3.
Yes.
It is brought to the notice of the court by so and so, theory for respondent to the property, theory number 1, let's see community say. No relief can be granted in favor of the petitioners in these petitions. The petitioners have approached this court after a long lapse of 40 years. The citing question is civic community site. Be that as it may, for the respondent to consider the representation of the petitioners by annexation M, dated 4/11/11 as per law and on merit. This order should not be meant that any positive order is made for the petitioner. Still directed me, my lord. The honorable court still directed me. Still directed me. I rejected it.
Yes.
For the record, therefore, my lord. And one last argument, my lord, was that building, taking possession of a building, they are presupposing that there is a building on the social property. That is an absolutely incorrect position. The reason is this. In the show cause notice that I issued to Sonar Yuvaka Sangha, asking them as to why I should not cancel the allotment because they're not implemented it. In that, my lord, this honorable court has appointed a court commissioner, my lord, to verify the state of affairs of the said land. The court commissioner has given a report. Kindly come to volume 1, page number 189. my lord.
Yes.
The respondents have filed
Yes.
The respondents have filed their objections to the said commissioner's report. A perusal of the commissioner's report will disclose that there is a temple constructed on the site. It also houses an idol of Ganesha, about 5'6" height. It was also surrounded by construction. So it is admittedly a temple. The report also would disclose that the rest of the area is left vacant. A vacant piece of land.
Yes.
Now they want to say there is a building, they have constructed a building. This was, my lords, in the year 2009. In 2009, the commissioner's report says that the land is vacant other than a temple. So the entire contention, my lord, is incorrect.
Yes. 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 Yes, reserved for judgment.
Grateful for the lord's kind indulgence in now.
Matter listed at 230. 52. Prithvi Odeya.
Statutory. First.
Yes.
I was referring to with regard to statutory committee and its this thing, Miller. In that background, kindly refer to first judgment in the compilation, second compilation that was given. 2022 1 SCC 294.
Yes.
just to have the this thing, my lord, kindly go to para 33.
Twenty
2022, 1 SCC, page 294, Muhammad Mustafa versus Union of India.
the second decision.
I think it's in the second in the second compilation, it would be the first judgment.
Yes.
Kindly go to para 33.
Yes.
It is relevant to note that the plea of bias did not find favor with the tribunal or the High Court. Before us, learned counsel for the appellant relying on Badrinath has submitted that even if one person of the multi-member committee is biased, decision of the committee shall be rendered invalid. Further, this decision holds that doctrine of necessity applies only in the case of a committee constituted by a statute or statutory rule. In other words, if the committee is constituted under an administrative order, there can be no difficulty in an officer recusing himself and requesting another officer to be substituted in his place. Even if a plea of bias is not raised earlier, it can be raised during the proceedings of judicial review. Further, even if bias is not a direct cause of the decision, test is one more of likelihood of bias, which in exercise of power, in respect of that case, para 34 says, in exercise of power under Article 32 and 142 of the Constitution of India, this court directed UPSC to constitute an empanelment committee to recommend 3 senior-most officers with good record of service and range of experience, and meeting their parameters, from whom DGP shall be selected and appointed by the government. Incumbent DGP of the state is a member of empanelment committee according to the draft guidelines issued by UPS. These guidelines, issued in compliance with the direction given by this court under Article 142 of the we would accept, are well known and in public domain. Therefore, the position that respondent number 5 being DGP would be a member of empanelment committee was within the knowledge of the appellant. Ignorance of the factum when pretended must be rejected as mere pretense. The 2 appellants are not laymen but senior police officers. Other things may not be necessary, my lord. Kindly go to 35. It is in this context we have to examine whether appellants are stopped from challenging the recommendations made by the empanelment committee, given the fact that they had taken a calculated chance, not protested till the selection panel was made public. In our opinion, ratio in Madan Lal would apply, and in the present case, as when a person takes a chance and participates thereafter, he cannot, because of the result is unpalatable, turn around and contend that the process was unfair or the selection committee was not properly constituted. This decision no doubt pertains to a case where the petitioner had appeared to an open interview. However, ratio would apply to the present case as the appellant too had taken a calculated chance in spite of the stakes, that too without protest, then has belatedly raised the plea of bias and prejudice only when he was not recommended. The judgment in Madan Lal refers to an earlier decision of this court in so and so, wherein the petitioner, of course, this thing is said. Then, my lord, kindly go to para
Yes.
Hmm. Of course, 39 refers to a multi-member committee, but it says it is in the Public Service Commission. A member, it's not a designated this thing, another member can be substituted. In this regard, my lord, your lordship may kindly see. Recounting ಆಮೇಲೆ ಇದನ್ನು ಶುರು ಮಾಡಿದ್ದೀವಿ. Relative.
You've
Court
taken
of-
us through the other judgments. You've taken us through the other judgments in the compilation.
In the compilation, this is my lord.
Yes.
Even in respect of bias, the court in this decision took the view that is 2002, 2 SCC 712, GN Naik versus Goa University. Your lordship may kindly turn to para 33.
Yes.
Para 33. Bias may be generally defined as partiality or preference. It is true that any person or authority required to act in a judicial or quasi-judicial matter must act impartially. If, however, bias and partiality be defined to mean total absence of preconceptions in the mind of the judge, then no one has ever had a fair trial and no one ever will. The human mind, even at infancy, is no blank piece of paper. We are born with predispositions, and the process of education, formal, informal, create attitudes which precede reasoning in particular instances and which therefore by definition are prejudices. It is not every kind of bias which in law is taken to vitiate an act. It must be a prejudice which is not founded on reason and actuated by self-interest, whether pecuniary or personal. Because of this element of personal interest, bias is also seen as an extension of the principles of natural justice, that no man should be a judge of his own cause. Being a state of mind, a bias is sometimes impossible to determine. Therefore, the courts have evolved the principle that it is sufficient for the litigant to successfully impugn an action establishing reasonable possibility of bias or proving circumstances from which operation or influence affecting a fair thing. Then, my lord, kindly go to para 36. As we have noted, every preference does not vitiate an action. If it is rational and unaccompanied by consideration of personal interest, pecuniary or otherwise, it would not vitiate decision. For example, if a senior officer expresses appreciation of work of a junior in the confidential report, it would not amount to bias, nor would it preclude that senior officer from being part of departmental promotion committee to consider such junior officer along with others for promotion. In the instant case, the allegation is so and so is a political disciple of the chairman of the selection committee.
Yes.
Such a relation, even assuming all those things are to be so, my respectful submission is not something creating a personal or pecuniary interest of bias that could be attributed. If that is so, as stated in this thing, every type of relation by itself will not create a bias. Then in the case of Charanjit Singh Malad, 2002, 9 SCC 732. Court of
Yes.
In para 2, small facts are given, my lord, which may be necessary to understand the other things. The principal ground raised before the High Court is that most of the selected candidates are related to the members of selection committee, and certain detailed averments were made in that regard in the writ petition as to the nature of relationship or how distant and how closely they were related to the members of selection committee and other details. They also set out some other defects in the matter of appointment, but the High Court relied upon only the aspect of relationship of parties without examining the replies filed thereto by other side, nor finding out the nature of relationship between the parties, and proceeded to hold that allegation which has been admitted is sufficient to show that there was bias in their favor, and hence the selection stood vitiated and quashed the same. An examination of the matter in detail would indicate, though some of the selected candidates were related to the members of selection committee, others were not related at all. However, certain rules have been framed by the Punjab Municipal General Rules so and so. Rule 7. No member of the committee shall be present or vote at or take any other part in any proceeding of a committee or subcommittee relating to a matter in which such member, either of his parents or descendants of such member, or descendant of any parent of such member, or descendant or parent of husband or wife of such member, or descendant of such parent is last referred to as a direct or indirect interest. Under Rule 8, such relations could be appointed with previous approval of regional deputy director. The rationale behind this rule is that in a small place like Mansa, most of the persons are related to one or the other. What needs to be considered is whether they are so closely related as mentioned in Rule 7 of the Punjab Municipal Rules or not, and whether they comply with Rule 8 or not. That aspect was lost sight of by the High Court, or rather brushed aside. Government itself on report, of course, government on accepting the report had confirmed the appointment. The court took the view, in a place like that, this allegation by itself is not something which could be considered as bias, even though some of them were directly related.
Yes.
Should be. Yeah, 96 Supreme Court could be. Yes, yeah. Of course, my lord, I wanted to cite that Asian versus Subramania Swami, my lord, somehow by mistake that citation is not brought. I will give it in the meanwhile.
Yes.
I'll point out the other two. The other day I submitted justification of the order to secure the records, etc. By hindsight, is not something which is permissible. Of course, this case arose from in an election petition. An order of recount was passed. In the recount, it was found that the returned candidate, the election petitioner had secured more votes than the returned candidate, and the result was announced. Your Lordship may kindly go to para 9 or para 7 itself for a moment. Recount was done. Para 6. In the recount votes, it was found that there was no difference of votes secured by the petitioner, that is 556 vote. But insofar as respondent number is concerned, he had secured only 528 votes as against 649. He was originally held to have secured. The excess 121 votes were found to be invalid votes. Therefore, the total number of invalid votes came to so and so. There was no difference in the votes of other persons. All the three contestants accepted the correctness of recounting and votes and signed a memo to the effect before the tribunal. Based on the findings of the recount, petitioner pressed for a declaration that he had been duly elected to the post of president. On the other hand, respondent number 1 prayed that tribunal should hold fresh election to be held for the president. Tribunal declined to order re-election, instead declared the petitioner so and so. Then para 9. Shri so and so, appearing for the petitioner and respondent number 1 respectively presented their case, their command. Shri so and so contention was that petitioner had placed sufficient material before the tribunal to make out a prima facie case for recount of votes being ordered, and that the result of the recount of votes amply establishes the truth of petitioner's contention. Mr. Garga argued that the allegation made by the petition in the petition were very general and vague in nature. Such vague averments can no stretch of imagination be considered adequate material by the tribunal to conclude that there was compulsive need for secrecy of ballot being violated and a recount votes was being ordered. Before examining the contentions of the parties, we may set out the position in law as regards the need for secrecy of the ballot being maintained and as to when the well-established rule can be departed from. Since the principle of law has already been enunciated in several cases, we may refer to 3 of those decisions. Dr. Jagjit Singh, so appellant, had challenged the election of the first respondent to Punjab legislative.
Can we go to paragraph 13?
Please, my lord. Paragraph 13 and 15. Thus, the settled proposition of law is that justification for an order of examination of ballot papers and recount of votes is not to be derived from hindsight and by result of the recount of votes. On the contrary, justification for an order of recount should be provided by the material placed by an election petitioner on the threshold before an order of recount of votes is actually made. Reason for this statutory rule is that preservation of secrecy of ballot is a sacrosanct principle which cannot be lightly or hastily broken unless there is a prima facie genuine need for it. The right of a defeated candidate to assail the validity of an election result and seek recounting of the votes has to be subject to the basic principle of the secrecy of the ballot, sacrosanct in a democracy, and hence, unless an affected candidate is able to allege and substantiate in acceptable measure by means of evidence that prima facie case of high degree of probability existed for recount of votes being ordered, election tribunal in the interest of justice, a tribunal or court should not order recount of votes. Then, referring to the same thing at the end of para 15.
Yes.
Para 15. Padmanabha also contended purpose and object of election law is to ensure that only that person should represent the constituency who is chosen by majority of the electors. That is the essence of democratic process, and this position has been observed by the bench of this court in the case of so and so. And hence it would be travesty of justice and opposed to all democratic canons to allow the respondent number one to continue to hold the post of the president of Panchayat when the recount disclosed that he had secured 28 votes less than the petitioner. We are unable to sustain this contention because, as we have stated earlier, an order of recount of votes must stand or fail on the nature of averments made and the evidence adduced before the order of recount is made, and not from the results emanating from the recount of votes. In the instant case, one of the submission we were making was your lordship said the other day, we given that first order, that is 9621.
It is here.
In that order, we'll just read that order. Through video conference, heard Shri Abhinay Vaiti, Learned Counsel for the petitioner. There is no representation either on behalf of the first respondent or the fourth respondent. Petitioner alleges bias and malafide on the part of the third respondent, without whose benevolence fourth respondent could not have been appointed as assistant manager MIS in the first respondent society. Petitioner and the fourth respondent were participants in the said solitary post, which was on 29/2/2016, and the written test was held on 18/12/2016. It transpires that in the written test, petitioner secured highest marks and the fourth respondent lowest. Nevertheless, this difference in the marks between the petitioner and fourth respondent, the fourth respondent is selected and appointed as assistant manager. Though the marks secured by the petitioner in the interview is not divulged, only marks of the fourth respondent is shown. Therefore, first and second respondents are directed to produce the original records. My respectful submission is, prima facie case of bias having been made out from the averments that is made, from the material that is produced, which resulted independently for the learned single judge to reach a stage of securing the original records, is something that is absent in the case. That too, your lordship may kindly notice the date of that order. It was during the peak period of second COVID. None had appeared for the respondents on that day. The order was passed. It is because of that record, all the further proceedings have taken place. My submission is, this order itself calling for records and looking into that records which has been made as the basis of proof of bias by hindsight is something which is not permissible to be done on the sketchy pleading made by the petitioner with regard to bias.
Yes.
Then in the petition,
Senior counsel, you had told us that you would have only.
in the writ petition, that is page 60.
We were assured that there will be 5 minutes argument today. We've heard you.
With regard to para 16, your lordship may kindly see, I am only referring it for the purpose saying,
Almost entirely we had heard.
I have contended
Yes.
that other participants of the interview are not made party, and other members of the selection committee are also not made party.
We have referred to that.
That's this thing. And this being a statutory committee,
Yes. All those arguments you had made on the last day, we have noted all those arguments.
So, with regard to statutory committee, I will just point out that decision in Sessions case, my lord.
Please make it available and what are the paragraphs you
I,
want to
I,
carry
I will point out that.
Yes.
Then, my lord, the other aspect is kindly see the final order by the learned single judge.
Yes,
Operative portion.
yes.
Appointment of respondent number 4 stands quashed, and respondent number 1 society is directed to conduct the interview afresh of the candidates who had been shortlisted and shortlisted after written examination and issue appointment order in accordance with law. In the event none would now respond, the appointment may be offered to the petitioner. It's as good as an appointment being made in favor of the respondent.
Yes.
It's not necessary that even in the re-interview, they may not select anybody.
Yes.
The direction to offer the appointment to the petitioner is something more than what is prayed in the writ petition or what normally is permissible for the.
Yes.
I will only point out that paragraph, the initiation case. The contention there was para 29.
Yes.
There is no doubt that when Constitution was framed, Constitution makers considered it necessary to have a permanent body headed by CEs. Perhaps the volume of work and complexity thereof could be managed by a single member body. At the same time, it was realized that with passage of time, it may become necessary to have a multi-member body. That is why express provision was made in that behalf in clause 2 so and so. It seems that for about 2 decades, the need for a multi-member body was not felt. But the issue was raised and considered by Joint Committee submitted report in 72. Since no action was taken on that report, Citizen for Democracy, a non-governmental organization, appointed committee headed by Shri so-and-so, a former judge of WHO, which submitted its report in August 74. Both these bodies favored multi-member commission, but no action was taken. After a lull, when Janata Dal came to power, a committee was appointed which submitted a report in 90. That committee also favored multi-member body. Prior to that, a multi-member commission was constituted, but we know its fate. But the issue was not given up and demands continue to pour in from members from parliament different views. These have been mentioned in the Court of Union of India. It cannot therefore be said that this idea was suddenly pulled out of bag. Assuming present CEC had taken certain decisions not palatable to the ruling party at the center as alleged by him, it is not permissible to jump to the conclusion that that was the cause for the ordinance or appointment of ECs. If such an excess is to weigh, CEC would continue to act against the ruling party to keep the move for a multi-member commission at bay. We find it difficult to hold that the decision to constitute multi-member commission was actuated by malice. Therefore, even though it's not permissible to plead malice, we have examined the contention and we see no merit in it. It is wrong to think that 2 ECs were pliable persons who are being appointed and with the sole object of eroding disease. We may incidentally mention Of course, that is with regard to appointment of 2 members. Kindly come to para 32.
We are
Now
also-
it must be
we are
noted,
A high-level committee appointing a CEC or
it's not that. It is statutory committee. Your lordship may kindly see how it is. Now it must be noticed at the outset that both clauses 2 and 5 of Article 324 contemplate a statute for appointment of fees and further service. Impugned law provides for both these members. No, my lord, I'm sorry. It's a wrong decision that is brought. It is the challenge to the ordinance that is brought.
Anyway,
I will give that decision and that paragraph.
we'd only like to state that the situation is very different.
Only that. With again making a simple emphasis that rule 17A, it's a statutory committee wherein chairman of the society is the chairman of recruitment committee. Please.
My learned friend made a serious attack on the relief granted, which is the last submission. I'll just refer the court to the, kindly see the relief. He has read out the relief. I'll not trouble the court with reading it. Kindly permit me to read my prayer in the writ petition at page 65.
Yes. Yes.
Page 65. It is prayed that this honorable court be pleased to issue a writ of mandamus or any other writ or order. Hold that the appointment of 4th respondent as assistant manager MIS in the first respondent society is non-est and is completely vitiated by bias and legal malefits. B. Consequently, direct the first respondent society to appoint the petitioner to the post of the said man. So I had made a prayer, and therefore the relief granted is in terms of the prayer made. More importantly, my pleadings were questioned as very sketchy. May I request the court to kindly permit me to show from my pleadings as to, if I may say so with respect, only one ground of attack for the entire this, namely bias.
Yes.
There is no other ground. Only one ground of attack. Kindly permit me to show that how the issue of bias itself came to my knowledge may be seen at page 62.
In that.
Paragraph 9. Paragraph 9. On the day the selection was announced, I did not know my marks. I did not know the marks of the successful candidate, much less did I know the marks secured by the other candidates. Para 9, I said so. It is submitted that on 24/2017, an interview was conducted of the top 5 ranked candidates who were called for the interview. In this interview, petitioner answered all the questions posed to him. Kindly mark it. I stated on oath that I have answered all the questions put to me, and this is an admitted fact. They have not disputed it. The petitioner was under the impression that he would be appointed as he had secured the highest marks in the written examination, as he had also answered all the questions posed to him in the interview. However, to the shock and dismay of the petitioner, fourth respondent has been appointed. Fourth respondent has been awarded, etc., etc. Those details are already given.
Yes.
Thereafterwards, what I did, para 11, it is submitted. In order to challenge the appointment of the fourth respondent, petitioner sought for copies of the applications received. The applicants called for interview. The marks awarded to the applicants and the appointment order issued to the fourth respondent under the provisions of the RTI Act. The first respondent, by an endorsement dated 21/8, has refused to provide any information or documents on the premise that the provisions of the RTI Act are inapplicable to it. Copy is Annexure C. So they refuse to give any information. It is there afterwards I make an inquiry. When this inquiry reveals, para 12, it is submitted that the petitioner recently came to know that the fourth respondent was a close associate of the third respondent, who is the president of the first respondent society and who was the chairman of the third respondent committee, which conducted the interview. That is how he comes to know after inquiry. It is submitted. Fourth respondent is basically a political disciple of the third respondent. This was the only reason for him being able to secure an appointment. This fact is clear from the post put up by the fourth respondent on March 30th. Madam, kindly mark the date of the interview. It was on 21/4. So 1 month earlier, on 30th March, there was a celebration. What was the celebration? It was the birthday celebration of the fourth respondent. So on that day, this fact is clear from the post put by the fourth respondent on March 30th on his Facebook regarding the birthday celebrations conducted by the third respondent. In the post, the third respondent has posted 7 photographs of the third respondent being garlanded and being affectionately fed a piece of birthday cake by the fourth respondent himself.
That was read out to us.
Yes. It is also seen in the photograph, fourth respondent who was proudly and happily accepting a piece of birthday cake from the third respondent. Mutual admiration. This post of the fourth respondent is captioned. This is the clinching point. He proudly announces midnight celebration with the boss. Long before the interview, he is celebrating the birthday of the boss. The copy of the Facebook, etc., etc. Then so other things are posted.
Yes.
And all these averments, the fourth respondent has not filed any objections disputing it. On this short ground, the writ petition was liable to be liable to succeed.
Yes.
Also, the third respondent against whom bias is alleged did not step into the court and deny the allegation made against him. It is in these circumstances, the learned single judge has elaborately considered all the allegations,
Yes.
has also reviewed the entire case law, and given the this thing, kindly permit me to read just one paragraph, para 17 at page 55, after reviewing the entire case law.
Yes.
A cumulative analysis of the facts, page 55. A cumulative, I think,
Yes.
a cumulative analysis of the facts, the judgments of the apex court, it becomes unmistakably clear that the selection of respondent 4 is vitiated by bias, as the learned counsel appearing for respondent number 4, selected candidate, admits that he had posted those facts on social media. Kindly mark it. There is a candid admission by the fourth respondent that he had posted the material on the social media, Facebook, and does not, however, dispute his relationship with the respondent number 3. So these are admitted facts. Not only he did not file objections, but he admitted, entered in the course of arguments, he admitted. It is his defense that merely because there is some relationship or friendship between respondent 3 and 4, it would not vitiate the selection, as he has been awarded marks by the selection committee. Respondent number 3 was the chairman of the selection committee, and all the members of the selection committee, including the chairman, awarded 0.5 marks to the petitioner. Madam, all the 5 members award only one figure,
Yes.
0.5, and award 2.5 or 3 to respondent number 4. Therefore, in the peculiar facts and circumstances of this case, as held by the apex court in the aforementioned judgments, the selection of respondent number 4 cannot but be to be vitiated on account of bias. It is also to be noticed that emphasis that respondent number 3, who was chairman and generator of the allegations, has remained conspicuously absent in these proceedings, perhaps deliberately, as he is served and remains unrepresented for the last 4 years. Therefore, it becomes clear that respondent number 3 has no answer to the allegations leveled against him in the petition. Shooting from either shoulder of the respondent 1 or respondent 4 would not suffice or be an explanation when he is specifically arrayed as a party. So these findings, the learned single judges, an attack was made on the order of the learned single judge directing production of the records. In a certiorari proceedings, this honorable court is always having an inherent power
Yes.
to summon the records and peruse them.
Yes.
And why, having admitted the relationship, how can this court be precluded from looking into the original records?
Yes.
Can that be a ground of attack? With these submissions, I very respectfully submit that
Your Lordship, may I make a
the
submission?
appeal is live.
Regard to appellant number in first appeal, a candidate, successful candidate, the only one submission which I am going to make is that on 8/5/2017, I have been reported to duty. Till from 8/5/2017 till date, I have been working, and I have been promoted as deputy manager now, and I have been working as deputy manager. And the other, my respectful submission is that, Your Lordship, there was no occasion or no objections have been filed to the writ petition. So there is no question of I admitting the allegation made against myself or the relationship or with the regard to photographs. And the only in the appeal, I have taken the contention that all those things have been disputed. So this disputed facts cannot be gone into in the writ proceedings.
Yes.
My very respectful submission is the learned single judge has recorded a finding that he candidly admitted before the court while arguing the matter. And so far as the length of service, I did not state it. He has already been suspended for misapproval.
Suspended and it
One
was
of the,
revoked.
in fact, very early in my career, when I was arguing a matter before learned illustrious judge, Mr. Ramajoyce, a probationer was discharged on an allegation that he has misappropriated. The learned judge said he should have waited at least till the probationary period is over. He should have waited at least till the litigation has come
Yes.
to an end. Please.
To judgments, my lord, I will hand it over to the court officer marking the paragraph.
So far as non-implement of the parties, my very respectful submission is other candidates there. Periyakurupan is a direct authority. They are deemed to have abandoned their claim for the post.
Yes.
Therefore, that's